Full house today. Good afternoon and welcome to the Appellate Division First Department. Those of you who are familiar with our practice already know my spiel, but I'm going to do it anyway, especially in light of the full house today. So, please know that this bench is familiar with your case, your briefs, your record, usually more than you wish we were. Okay? So please, I need you to ask and limit your time request to what you actually need, not the pie in the sky, what you want. I have 7.5 hours of requested argument time. Newsflash, we're not going to be here for 7.5 hours. So I need you to all cooperate, and please know that your colleagues at the end of the calendar will really appreciate you asking for just the time that you need. And lastly, know that the time clock is for you, not for the court. So if my colleagues have additional questions beyond the time that I have allotted, because you're so brilliant in your argument, I will allow the time to continue. Okay? All right, that being said, first case on the calendar, People v. Shaquana Carter. Okay. Okay, 5 and 1 and 5. Koval versus Access Industries. 5 and? Okay. All right, 5 and 1 and 5. K. Patricia versus David K. is submitted. Jones versus Marshall. Oh, I like you. I'm sorry? 4 minutes. 3 and 2 and 4. Rosario versus Franklin Plaza Apartments. Okay. 5 and 2 and 5. Thank you, gentlemen. Citigroup Global Markets versus SCIP Capital. This is one of the cases we think needs a little more time. So tell me where's the other side? Oh, okay. All right. I was going to be very shocked. Go ahead. Okay. Not quite that much time, but go ahead. All right. So let's do 7 and 2 and 8. People versus Jason Washington. Okay. 5 and 2 and 5. People versus Karen Eggers. Okay. All right. Let's do 6 and 1 and 5. Silva Rios versus New York Presbyterian Columbia. Okay. 5 and 2 and 5. HNA Holdings versus TSCE 2007, same thing. I think this one needs a little more time, not 10 and 3, but I'll hear you. I'm sorry? 8 and 2, Your Honor. Perfect. That's exactly what I had in mind. And you, sir? 8. 8 and 2 and 8. DM Children. Okay. You're kidding, right? Try again, because you're not getting 8 and 2. 4 and 2. No, you get 4, and you'll get 2, and you asked 4? Okay. 4, 4, 4, and 2. Okay. Denmark versus New Chapter. Okay. Okay. People versus Cashon Jones. Okay. 4 and 2 and 4. Tillipman versus Corbin. Submitted. People versus Amy Hartsgrove. Submitted. Imovici versus Castle Village Owners.
Your Honor, 5 and 2, Appellate.
Okay. 5 and 2 and 5. I know I'm going to mess up this name, so I ask for forgiveness now. Salowiski versus, okay, thank you. I tried. Versus Lou. Thank you. Have a seat until the end of the call of the calendar, and then you can leave. Thank you very much. People versus Franklin Quiles. Okay. 4-1-4. Izquierdo versus Amsterdam Avenue redevelopment. Those two cases will be heard together. Okay. So just 3-1. All right. It's an unenumerated appeal, so it doesn't get argument time. Anytime you want to use from your 3 minutes to address any of those issues, feel free. Okay. N47 Associates versus Gemsco Realty is a submit. First case on the calendar, People versus Shaquana Carter. And a happy holidays to everyone in case you leave before I'm able to say that again, all right? You may proceed, sir.
Good afternoon, Your Honors. Harold Ferguson for Appellant Shaquana Carter. Here, the evidence was legally insufficient that Ms. Carter knowingly possessed stolen property. The jury determined she didn't steal the complainant's credit card, didn't steal his debit cards, didn't possess them, didn't steal the wallet. And
The
all
jury found that the people had not proven beyond a reasonable doubt those things. And what the basis for that was, under the facts and circumstances of this case, is anybody's guess, right? Because I could absolutely see this jury saying, are we gonna send this mother of a disabled child to jail?
Well, also, Your Honor, even the prosecutor at one point indicated that she understood the defects in the case and that there was a reasonable possibility that there would be an acquittal on the debit and credit cards, although the judge vehemently disagreed with that. Someone stole the wallet, and my client disposed of a nondescript empty wallet into a trash can. There's nothing in the record to establish that she understood and that she knew that the item that she discarded in the trash can was a stolen wallet. If the suggestion is that it was her child that stole the wallet, a 4-year-old is incapable of stealing. They don't have the intellectual capabilities to form the intent to steal. She saw a wallet in her child's hand. She looked at it. There's no ID in it.
Counsel, look, I appreciate your argument, but there was a video surveillance showing that the gentleman whose wallet became missing left it on the counter, and your client swooped in immediately as he walked away from the counter and kind of slid it out of the way, and it fell to the floor, and then her developmentally disabled son is utilized to pick up this wallet. Okay, so again, the jury, I could absolutely see why the jury here, in light of those facts, would say, there's reasonable doubt, and we're not going to take the chance of stripping this mother from this needy child.
Okay.
Right?
Let me move on to the second.
Yeah, why don't we do that?
The second point, Your Honor, from the outset of this case, for whatever reason, the judge had an overt bias against my client. Before the trial even began, he threatened to put her in jail. He threatened to have her child removed through IACS. And throughout the proceedings, indicated that he firmly believed that she was guilty. When she appeared for sentencing, he had everything that he needed in order to make a sentencing recommendation. If he really believed there was a problem with the child, he could have referred her at any moment to ACS.
Counsel, the delay that you're speaking of, is it so unreasonable given the fact that the judge requested certain things from your client and your client refused to provide them?
She had no obligation to provide those under the law,
Well, the judge has wide latitude regarding the different factors that the judge would take into account for sentencing. And one of the arguments from your adversary is that the defendant, being a mom and taking care of her child was a factor in whether the judge would sentence to jail.
Well, what he was looking for was his educational records. But again, at that age of the child, the child had no obligation to be in school because the child was not 6 years old.
You know,
I'm sorry.
that argument is so offensive on its face, because we know that early childhood education makes all the difference in the world in the development of a child's mental capacity. So to argue that it is okay and that a judge cannot question whether a 5-year-old who is not registered in school, whether that is a problem with regard to their care, I don't see a problem with that.
But, Your Honor, she was indicating that she was homeschooling her child, which she had the absolute right. She wasn't saying that.
She does have the absolute right, counsel, and the judge, worried about the child, wants to see it. You're homeschooling this child? Show it to me.
But again, Your Honors, under the law as it is, there are specific things that need to be done when someone is homeschooling their child that don't come into effect until the child reaches a particular age. At age 5, she does not have a reporting requirement, so there would not have been anything that she could have submitted. And again, you have to take a look at the overall picture of this, that this judge had a bias against my client, and everything that was needed to make a sentencing determination was present.
You'll have time on rebuttal. You may proceed.
May it please the court, Peter Rienzi on behalf of the people. This court should affirm for 2 reasons, Your Honors.
So how do you address the fact that the record does seem to suggest that the judge had a preoccupation with the education of this child? How do you address that argument by your adversary? Because the sentence was delayed a number of times, right?
Yes, Your Honor, that is true. It was appropriate for the judge to be concerned about this because the evidence of the trial showed that the defendant appears to have used the child in committing the crime, or at least...
Appears to is the operative word there.
That-
So then the
that's correct.
question is,
Yes.
were all of these, because of course now I play devil's advocate on the other side, did the court have other options, like referring the case to the family court, which could have properly dealt with this issue if indeed that was the real reason for the delay?
Or ordered an ACS court-ordered investigation to do the legwork on this?
Your Honors, those sound like those would have been appropriate options as well, absolutely. The court did attempt to get this information from the defendant. There were numerous adjournments where there was a hint of some progress being made. There were times when defense counsel said, "Judge, give me one adjournment." The first defense counsel said he would get the father was interested in getting the child evaluated. Then when the second counsel took over, she asked for a few-month adjournment to look into who might evaluate the child. So there were hints at cooperation and hints at progress that, of course, did not end up...
Except throughout the entire process, this mother continued to question the court's authority to request and require this information.
She had no criminal record.
That's correct.
She's found guilty of criminal possession of a stolen property in the 5th degree. And so now we're grilling her on how she mothers her child.
Well, Your Honor, I think saying that we're grilling her is...
Again, counsel, he could have ordered a court-order investigation. He didn't need her. He could have ordered ACS to go to her home, to look into the school, to see about the homeschooling, to call the Board of Ed.
Right. I mean, but what he did do was he asked her for the information, asked his attorneys for the information, tried to handle it with a second pre-sentence investigation by the probation department. Obviously, none of these things yielded the information that he was seeking. But there is no doubt that if the defendant had provided this information and if the defendant were homeschooling the child, this would have redounded to the defendant's benefit. This would have been another...
Was the information ever provided?
I apologize.
Was the information ever provided?
No. I mean, there is
sentencing occurred without the judge having that information.
That is correct. That is correct.
So what changed the judge's concern suddenly? He wanted to
Other than the
dispose the
motion saying
case?
you're violating my rights.
It's not clear, Your Honor, what motivated the
It's
judge to.
pretty clear. It wasn't until that motion that the judge finally sentenced the defendant.
I understand, yes. I mean, he did, obviously, the judge did deny the motion and the-
Counsel, was this verdict against the weight of the evidence?
Absolutely not, Your Honor.
Why not?
It wasn't because the evidence clearly showed, as some of Your Honors indicated when my adversary was speaking, the video clearly shows an intentional act by the defendant in taking her right arm, which is holding something else, and maneuvering that wallet off the counter. Then later, the defendant admits possessing the wallet and disposing of it on the street.
Was that the first time that she was asked about the wallet, or was she asked about the wallet before and said she didn't know anything about it?
Well, the two of the people's witnesses said that she had been asked, I'm sorry, three witnesses total said that she was asked about the wallet. She denied that, but the witnesses were clear that she was asked about the wallet.
Although she did acknowledge being asked about the credit card and
Yes.
seemed to draw a distinction between the credit card and the wallet.
Right, Your Honor. Yeah, absolutely, she did draw that distinction. But yes, just continuing with the evidence, it clearly showed that she knew that this was stolen property. Obviously, it's not her wallet. There is no reason for someone to put their elbow on someone else's wallet, then have it disappear. Then suddenly she does have it, but she blames her child. So the evidence certainly was sufficient and consistent with the weight of the evidence. If I could briefly address the delay in sentencing again, the defendant consistently frustrated the entry of judgment, and dismissing the case as she requests would allow her to benefit from the delay that she caused. Thank you, Your Honors.
You have 1 minute.
Just a couple of things, Your Honors. There's no documentary proof that these debit cards or credit cards ever existed. They didn't put anything in that indicated these credit cards and debit card ever existed. That would have conclusively determined if someone else had stolen it. If this wallet contained those items and those items were not, he never said he canceled those credit cards and debit cards. So if they were used afterwards, that indicates someone else stole it. Two, there is a father involved in this, so that the judge could have sentenced her and sent her to prison, and the father would have taken custody of the child. And lastly, Your Honor, my client could have refused to answer.
Nothing in the record to support that, but go ahead.
Yes, there is, Your Honor, because
That he would have taken custody of the child?
he was already paying child support. He came to court with her and was taking care of the child at the early proceedings, that he was present in the courtroom.
All right.
And lastly, Your Honor, my client could have refused to answer the Department of Probation's questions when she was interviewed. Ironically, I received a brief from the people yesterday where the argument was that because my client refused to be interviewed, that the sentence could have proceeded without that information. So she did more than that individual, and the people took the position that you could have sentenced my client in that case without a pre-sentence report interview. Here, she completely complied with the probation interview and answered all the questions and provided a complete accounting of her life. Thank you, Your Honors. Have a wonderful holiday, everyone.
Koval versus Access Industries. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court, Hillary Simon, Kennedy's Law for the defendants appellants. This appeal asks the court to correct an improper exercise of discretion under CPLR 327A. The Supreme Court retained a case with no meaningful nexus to New York, despite that the
So
incident
the
occurred.
defendants have their corporate offices here. So that's a meaningful nexus to New York. And according to the complaint, if I recall, the design for the subject steam room was done here in New York, and several other contracts in question were done here in New York. So why isn't that enough?
Yes, Your Honor. So one of the defendants' OC is a resort in the Bahamas, and Four Seasons is a Canadian corporation which has no connection to this, in this case, to New York. And Access Industries has a mailing address in New York, but
Excuse me, didn't both Access Industries and OC Resort Holdings have a corporate office here in New York? They actually shared an office here, I believe, on Fifth Avenue. And didn't they also have a management agreement with the Four Seasons Hotel, then in the event there was any dispute that those parties had, that they would litigate here in New York? So, I mean, to say they have no connection to New York seems a little strained.
Access Industries has a mailing address in New York.
No, they
and I
have
can
a principal place of business. That is a legal situation, right?
Yes, Your Honor, but I can address both the management agreement as well as Access Industries' connection to New York. So under the Court of Appeals case, Pahlavi, that's not a meaningful substantial nexus where the accident wholly occurred. The situs of the accident was in the Bahamas.
Well,
He's
yes,
alleging that-
but we understand that, but nobody really has a connection to the Bahamas, and the plaintiff would not be able to have a jury trial in the Bahamas. So there's, these are all things, I've made hundreds of decisions over the years on forum nonconvenience, and there's a lot of different elements we have to consider in these cases.
Yes, and this is one of the rare cases where every Pahlavi factor holds against having it remain
No,
in
it
New York.
doesn't.
No,
I
counsel.
disagree with you 100%.
The accident,
The accident happened in the Bahamas, and no one in this case is a Bahamas resident. So that is not an appropriate forum. And as my colleague just said, the plaintiff would be denied the right of a jury trial. So that is not something that our courts favor.
right, Your Honor, but all of the witnesses, it would be substantially prejudiced to my clients because all of the witnesses
And
are
which
in the
witnesses
Bahamas.
all
did
of
you,
the witnesses.
which witnesses did you outline in your papers?
The,
Right? Because
the
I have
medical,
the plaintiff and her daughter
daughter.
who live in New York.
the plaintiff does not live in New York. She's a
The
Pennsylvania resident.
plaintiff's daughter lives in New York.
That is
The only sole
only-
witness to
that is
the
also-
accident.
One suggestion to you, when the court is talking, you should not be.
Yes, Your Honor.
Okay. You had a question,
No?
Go ahead. Go ahead.
The fact that one witness is a New York witness, that is actually
Counsel, she's the only sole witness to the accident, correct?
to the actual accident itself, but there's
Yes,
liability.
yes?
Liability
Was she the sole witness to the actual accident itself, using your words, yes?
to the actual accident, yes, but all the other liability witnesses, including former employees of the hotel who are relevant to our liability case, as well as medical
This
personnel.
is the corporation at issue here has no problem flying people in for a trial.
Right, but it's
So that is not an undue hardship. And under our case law, if a case is properly venued, then you must show sufficient evidence why it shifts to the other side because it is so inconvenient. And tell me how you have established that here.
We don't have subpoena power as to any of the former employees, any of the medical staff. She had all of her treatment in the Bahamas as well as Pennsylvania. She didn't have any treatment here in New York. In addition to that, the other witnesses and all of, well, I want to go back to something that was said about the documents as to the steam room itself. That was purely based on speculative evidence. There's nothing in the record that shows that design or construction occurred here. The only documented facts show that the spa was constructed, operated, maintained, and
Was the designer for the steam room a Bahamas-based design company?
yes, Your Honor, everything happened in the Bahamas. Nothing happened in New York.
Where in the record is that?
Well,
No. I asked you a direct question, and you gave me an answer. So I need you, because your time is up, I'm gonna have the other side argue, and I want you to find me the page citation that tells me that the designer of the steam room was a Bahamas-based company, as you just said, okay? You'll have time. Counsel?
Good afternoon. On this motion, it's the defendant's appellant's heavy burden to establish that New York is not a convenient forum and is unfair to bring the defendants into New York for this case. Defendants have not produced anything into the record to establish that this is an inconvenient forum or an unfair forum.
Are the witnesses named? Specifically, which witnesses would be required who live in the Bahamas and would be incapable of coming to New York for a trial?
There's nothing like that in the record, no.
So it does not lay out who the witnesses are, what they would testify to, and why they were important to the case, and why it needs to be changed, the venue.
Or even why they would be inconvenienced to, if they had to come to New York, which is one of the things that they also need to show with their heavy burdens. So they don't have that either.
That's not in the record, that's
The
correct.
only witness that we have in here is your client's daughter, who does live here in New York.
That is correct. And not only are the defendants residents, well, not only is Access and OC residents of New York City through their principal place of business and Access actually incorporated in New York, the complaint establishes allegations that the negligence that precipitated the accident in the Bahamas were actually committed in New York. That
The defendants controlled and financed the renovation of the spa here in New York City.
Correct. And Access Industries is a real estate developer who sponsored a loan to purchase and renovate the premises. There is no physical location in the Bahamas for the Access. OC is just a shell corporation, even on the certificate of insurance,
And
which
they also have the same principal place of business as Access, correct? They would have the same address.
they have the same principal place of business and they have the same corporate directors who are also New York residents. And unless there's any more questions, I'll sit down.
Thank you. Counsel, you have a minute.
Yes, Your Honor, I'll just address your question. So this was a pre-answer motion to dismiss, so it's pre-discovery, and plaintiff has the burden of showing more than speculation.
But you made the motion to dismiss the complaint, so it was your burden, not theirs.
Right, but they
You've
only,
raised that this is an inconvenient forum, so you have the burden of establishing that.
yes, but I'm answering the question as to, you asked about the design and of the steam room, and all of that was speculative. There's nothing in the record that.
I understand that, but since your side is the one making the motion, you have the burden, right?
Yes.
So if you know what they're going to say, you had to come forward, perhaps present documents that show the design firm who did the spa in Bahamas was a design firm in the Bahamas, and what they were saying was not true. That's what you had to do. They didn't have to.
Right.
Right?
And so, but just on its face, the factors here don't show that the case should stay in New York.
Okay, thank you. Jones versus Marshall. And you asked for 3 minutes.
Thank you. May it please the court. Brendan O'Mara. It's not a case where there's a tremendous amount of facts in question. It's more of the applicable laws that have to be applied and whether or not Marshall can delegate their duties or responsibilities to a third party. I think the brief kind of lays out relatively specifically that they cannot in this particular instance, particularly when you look in light of the facts of where the accident occurred.
So Marshall's, I mean, your point, I think, is that Marshall's has a non-delegable duty to keep the premises safe.
Yes,
And that sort of would keep them in at this point,
yes,
even with an independent contractor having been involved.
yes.
Anything? Guess we agree, but.
Okay, why don't I save your time for rebuttal?
Okay.
All right.
Afternoon. May it please the court, Deborah Summers for respondents. I know the court is very familiar with the arguments laid out in the papers, so I just wanted to use my time to address a few things that plaintiff raised in the reply brief. They've made efforts to distinguish some of the cases upon which respondents rely. One of the things they tried to distinguish the Bergdorfer case by arguing that plaintiff only owes a non-delegable duty when it relates to a public area of the building. And I'm not quite sure I understand where that even comes from. However, in trying to distinguish the Spitzer and the Fisher cases upon which we also relied, plaintiff,
But here, this is not here the area in question was undoubtedly an area used by the public. So that's really the only case law we need to concern ourselves with for the analysis of this case, right?
I would agree with that, although I think the other cases are also applicable, and the Spitzer and Fisher cases did deal with public areas. Plaintiff was suggesting that they didn't and that they might be held to a different standard. But in fact, in the Spitzer case, the appellant's brief says plaintiff had just entered the shopping center from the parking area, and in the Fisher case, the decision says that plaintiff slipped and fell exiting the restroom. So I just wanted to note that I do think those cases are relevant here. The other thing I wanted to address is we don't disagree that the owner of the property has a non-delegable duty to maintain the premises safely. What we do disagree with is plaintiff's assertion that that notice is irrelevant to that analysis. So in essence, they're trying to say—
But is notice even an issue here where your own witness says she sees the fall? Your own witness says she sees the cleaner cleaning against office policy, against Marshall's policy, because the store doors had been opened and your policy is you don't continue to clean the floors once the doors are open to the public. And yet you have a manager on the floor with an eye shot of the fall and of this independent contractor cleaning the floor. Oh, and she notices, I didn't see a watch where you walk sign up.
I think she said she didn't recall whether or not she had seen a sign.
That
which
to
is
me means it
slightly
wasn't there.
different.
If she doesn't know, then it doesn't exist, right?
We don't disagree.
Okay.
But we know the sign was not there, admittedly. The question is whether she knew that at the time. But I think the important thing
But
is—
no, what's important is that she could see him cleaning and they opened the doors to the store and allowed patrons in violation of your own store policy.
I think plaintiff's counsel makes much of that one single line in the time and attendance section of the contract. There's nothing in there that says that the reason that they don't want to have the cleaners on the floor of the store while, during business hours, there's nothing in there that says that that's for safety reasons. That prohibition—
Why else?
Because they
Why else?
Because
counsel?
it's—
That's like common sense.
Well,
right?
Your Honor,
You
wouldn't—
don't want to have a big machine that's wheeling around while customers could be going up and down the aisle.
Agreed, but the prohibition is not limited to the use of floor cleaning machines or even mopping. It applies to any kind of cleaning activity on the sales floor. So if you're using a feather duster to dust a windowsill—
That's not what we have here. So I appreciate your attempt to throw that argument into the mix, but that's not what we're dealing with. We're dealing with someone buffing the floors, not putting up the cone, knowing that this buffing machine spits out water sometimes that needs to be dried up. So all the more reason why a sign, knowing that, would have been crucial.
There's no evidence that the store manager said that it was her understanding that the machine dries as it goes. The contractor said that he was aware that it occasionally happened, but the store manager didn't acknowledge that. Thank you.
I have nothing further.
Thank you. Have a good day and happy holidays to you both. Rosario versus Franklin Plaza.
May it please the court, my name's Kevin Brennan. On behalf of the appellants, I ask that you reverse the summary judgment award because there's a plausible view of the evidence on which a reasonable jury could conclude that it has not been proven that Mr. Rosario's fall and injury resulted from an inadequate safety device.
Isn't that a question that's a matter of law for the judge to decide?
No, I think that's a question
I
of,
think that given certain facts, it could be a question that the court could decide as a matter of law. So explain to me why on these facts, the court was not perfectly entitled to decide this as a matter of law on the facts before the court.
because there's evidence on which, if it's viewed in the light favorably to the non-moving party, which creates a question whether, that gives evidence on which a jury could say that we don't believe that the fall resulted from the ladder moving.
What is that evidence that you could use?
Sure. First, the jury could believe that Mr. Rosario told the emergency room doctor that he fell and landed with his right leg being bent back behind his body.
What does that have to do with the liability? What would that have to do with the liability? What would that have to do with the finding of summary judgment?
It has to do with the liability because it has to do with Mr. Rosario's credibility. If you look at the evidence
So
as
you
a
want to have a jury speculatively surmise that because of the way his leg fell after he fell, what he said about how he fell couldn't have happened.
No, I don't think you can take.
That they should be able to speculate about that without any evidence whatsoever.
No, I don't think that's what I'm saying.
Okay.
I know that's not what I'm intending to say.
Okay. Good, I'm glad.
I'm saying that if you look at the evidence as a whole, in the light most favorably to us,
Except that what you're saying is, what I have here is no one else witnessed this accident, right?
Pardon me?
No one else witnessed this accident, correct?
Correct.
Okay, so our case law says we don't have to have a second witness for the plaintiff to be
I
able-
don't dispute that.
Okay, so then what I need in order to say that there's an issue of fact that should go to a jury is something that controverts anything that the plaintiff said that's admissible.
Well, what's admissible
What's admissible?
is the statement from the doctor that said, he told me he fell and with his right leg bending.
Right, but how does that controvert what he said? How because the statements, any statement in a medical record to be admissible has to pertain to treatment.
No, I don't.
Oh, yes, it does, unless the statement completely and totally contradicts the statement of the plaintiff of what happened.
I disagree.
Then you can bring it, then you can say there's an issue of fact.
The statement is admissible under the past recollection recorded exception to.
But didn't the
Also,
doctor
yeah.
also say in this particular case that generally when he took notes, if he
Was quoting.
put quotation marks in it, that would mean that that's exactly what the plaintiff said. But since there were no quotation marks in this particular report, he may have been paraphrasing what plaintiff's description was, and at this point he couldn't remember exactly what it was. So we have a paraphrasing.
Well,
does that
first, that would go to the weight of the evidence, not to its admissibility.
No,
There are four-
actually, in order to allow evidence in from a medical record, the record must attribute the statement to the patient. So it must say the patient said XYZ. If it does not say that, then it is hearsay. It must be attributed to the patient, to the affiant.
The doctor testified at pages 601 through 604 that he took the history he got the history of what he wrote from Mr. Rosario. The doctor was then asked at pages 609 to 610.
We're familiar. We're familiar. And he also,
He's asked if he accurately recorded what was said.
and he
"Yes,
said,
he did."
and he said what my colleague said. When I am quoting a patient, I put statements in quotations.
There's no
R614, by the way.
requirement for admissibility that he quote the patient
It
exactly.
must be quoted.
No, I'm not aware of.
Counsel, I'm not going to debate this with you, but you'll have time on rebuttal.
Thank you.
May it please the court, Ed from Morton Child for the respondent. The plaintiff established a prima facie to labor law 240 case. The latter shifted. That's his testimony. That's conceded here, even by the appellant. The burden then shifts to the defendant to submit admissible evidence that the latter did not shift. There's not one iota of admissible evidence in this record that contradicting the fact that the latter shifted.
So the counsel spent a lot of time talking about the doctor's testimony. So can you talk about that? Is it admissible? And even if it were to be admissible, does it in any way contradict with what the facts that your client alleged or the allegations your client made?
First of all, it's not admissible because it's not a quote. At page 614 of the record, the doctor said, I do not recall in this case, but in my general practice, if I quote a patient directly, I will put quotation marks. There are no quotation marks, therefore it doesn't come in.
That's what I said, right.
Even if it came in, I have no idea how, if the leg ends up behind his back or something, that has to do with anything with the ladder shifting or not shifting. A person, in my view, can, if the ladder shifts and falls, it can still fall with his leg bending behind his back. There's no biomechanical.
Any expert evidence introduced into this record that said if the plaintiff had fallen from the ladder the way he said, his leg wouldn't have landed the way it was?
Not at all. There's no biomechanical expert. It's far beyond the ken of any layperson to say that. So there is no evidence in this record. It's totally bereft of any evidence whatsoever that the accident happened in any other way than the ladder having shifted.
Thank you.
Thank you. Thank you.
The point isn't that the evidence shows that the ladder didn't move. The point is that the evidence gives grounds for a reasonable jury to doubt the credibility, the truthfulness of Mr. Rosario. And Mr. Rosario has the burden of proof at trial. On the question of whether this statement to the doctor is admissible without it being in quotation marks, I cited to People Against Taylor in both the main brief and the reply brief, and quoted from Taylor in the reply brief at page 7 that the requirements are 4.
Counsel,
I'll make sure that any decision gives you the citation of what I am speaking of, because it is an old case and has not been reversed.
Well, what Taylor says is that the witness must have observed the matter that's written in the record. And in this case, it means he talked to him, talked to Mr. Rosario. The second is that it was done when it was fairly fresh, when recorded or adopted. And the one that matters that we're talking about is that the record correctly represented his knowledge and recollection when made.
But how does that, in any event, contradict what plaintiff said? How does that raise an issue of fact as to what the plaintiff sustained his burden of making out a prima facie fact? How does anything you say raise an issue of fact as to how the accident happened?
It raises an issue of fact because, number one, plaintiff denied saying that. Number two,
But what does that have to
Yes.
do again to the issue of liability and this safety device not being effective for the purposes of what it was supposed to be effective for?
because credibility matters in liability too. And
But it has to be credibility with regard to how the accident occurred, not this other stuff, this extraneous stuff,
There's a
and general credibility.
there's a discrepancy between what plaintiff said at his deposition, that he was thrown to the right, hit the railing, bounced back onto the ground, landed on his back, bounced up in the air, and then landed on his knee.
Thank you. You'll be able to utilize all of that at trial. Thank you. Citigroup Global Markets versus SCIP Capital.
Good morning, Your Honors. Shomit Ghosh on behalf of the Silverfern Appellants. The trial court's decision must be reversed because it disregards black-letter law of contract interpretation. It violates the presumption that the parties who are sophisticated come to the defined terms they wish to apply. It
In
ignores.
terms of the black letter law of contract, what exactly are you talking about? Are you talking about how investment partnerships were defined?
Yes, absolutely.
And in this contract, how were they defined, and in what page of the record was it defined?
Well, the recital A of the distribution agreement defines investment partnership as a limited partnership with which an affiliated entity will invest alongside it. And in this instance, what we are discussing is an RSMA SMA product. And the record extensively reflects that that product was comprised of two components. First, the Silverfern Invested Limited Partnership 2 LP, and alongside it, the RSMA SMA product.
So
Critically,
are you saying that the trial court's decision to look at the contract as a whole in terms of deciding how you defined an investment partnership was inaccurate?
it was not only inaccurate, it was improper. It was improper because the defined term that these sophisticated parties arrived at.
There's case law that permits the trial court to look at the contract as a whole to glean definition, right?
Of course there is,
And
but
how is what happened here contrary to that case law?
well, it's contrary in the sense there's no ambiguity, but to the extent that what you're suggesting is the trial court should make sure the definitions are compatible with other provisions, had that occurred correctly, the trial court would not have reached the definition it did. The trial court's definition of investment partnership, and I just want to quote it.
So I want to, in light of what you just said, is your complaint that the judge made the wrong interpretation after looking at the agreement as a whole, or that she looked at the agreement as a whole?
Both. I believe defined terms should be applied literally unless there is some problem with them in the broader contract. So if there's an ambiguity, unworkability, it frustrates the purposes of the parties, then you can maybe look behind. But when sophisticated parties use defined terms, these are defined terms, that should be applied literally unless there's an ambiguity. The trial court finds some ambiguity. But to the other part of your question, we strongly disagree with how the trial court, even if it cast aside the defined term, it came to this new definition. It is the definition the trial court arrived at cannot be correct. And the reason is it directly conflicts with Section 1E of this contract. The trial court defined an investment partnership in this way. It says the only reasonable interpretation is that the parties intended to capture those investments that were specifically offered to Equity Club members. The key word, specifically offered to Equity Club members. Now look at Section 1E. It says in the beginning that certain investment partnerships will not be offered to the Equity Club. It says city in its discretion may decide not to offer certain investment partnerships to the Equity Club. So if the court in its deliberation takes the trial court's definition and just puts it into Section 1E, every time it says investment partnership, you take the trial court's definition, you will see that it's circular, because it would suppose that
So are you saying that the trial court defined investment partnership as only those vehicles of investments that were offered to the Equity Club?
Yes, Your Honor.
And that was inaccurate?
Yes, Your Honor, that's a
Now, let's talk about breach, though, right? Because at the heart of this controversy is who breached the contract, right?
Yes, Your Honor, it's at the heart of it. I would agree with you. That's the direct quote the trial court made about investment partnership. It's that an investment partnership is only a vehicle offered to Equity Club members. That's the trial court's quote. But yes, it's, to the extent it's about breach, we argue city breached by
Okay, well,
writing-
let's talk about your responsibilities under the contract. And when I say your, I mean Silver Fern. Did you not have a responsibility before offering an investment partnership to any of the Equity Club members to get it approved by Citibank first?
Well,
Is that not a provision in the contract?
it's not, it doesn't exactly work like that. So Section 1E of the contract is what I would consider the pipeline provision. It discusses the birth, the life, and the death of an investment partnership. And an investment partnership is born without Citi being involved. That's the top end of 1E. Then it is presented to Citi for them to consider whether it will be added to the Equity Club. That's the middle provision of 1E. And if Citi decides not to offer it to the Equity Club, then Silverfin may move forward. To answer your
Well, it
direct
seems like you skipped over.
they can offer it to other parties. That city has the right to decide if it wants to bring it to the Equity Club.
Well, it seems like you skipped over a portion of 1E, which I'm looking for it and I'll bring it up, which specifically says that Silver Fern is not permitted to offer, and that's 1E, where it says, for avoidance of doubt, interest in any investment partnership will not be offered to any Equity Club investor who is a client of the placement management without the prior approval of the applicable placement agent. So that to me reads that you have to get approval from Citibank before you're able to offer any investment partnerships to any of the Equity Club members.
It has to be submitted to Citibank, which it did. You can look at A1556, which is a 2014
Yeah, but after
letter.
it's submitted, do you have a responsibility to wait for an approval before you offer it?
It's technically 10 days.
It's what?
Well,
Technically 10 days.
yeah, but if you go down into that provision, there's more language about getting approval. So you're pointing me to the time frame that you have to wait, right? But within that provision itself, there's more information that you're not even allowed to offer something that hasn't been approved.
So the way we read the contract is upon submitting it, city either can approve it, deny it, but there's 10 days after which there can be discussions. That's why you'll see in the record
No, finish. There can be discussions and.
with investors of the Equity Club that occurs without city's formal approval if city has decided either not to approve it or has waited beyond that
So
period.
if after 10 days, you have not heard yea or nay, according to your reading of the contract, you are permitted to offer these investments that have not been approved to Equity Club members.
You're able to, my time is up, but you're able to make that discussion. And most critically,
When you say make that discussion, what do you mean? Are you able to offer it or not?
you're allowed to have conversations with Equity Club members.
Counsel, we're lawyers too, okay?
I-
She said offer, and you say we could talk about it. The question was, can they offer your investment vehicle to an Equity Club member that Citibank has not yet approved, is the question.
If the city does not respond within 10 days or take the appropriate actions permitted, yes, they can make outreach and solicitation.
What-
Offering under the Equity Club is a different concept.
What provision of the contract specifically says that? Just for
Well, I think 1E, as I've said, explains the sequence and it creates a timing requirement. But the critical part is city itself recognized these
So
conversations.
there's no provision that specifically says what we just said. You are arguing that 1E intimates that.
Right. By saying that, it creates a timing, right, a timeline that this offering or waiting can occur. It doesn't still yet say that the contract permits you to offer it before you receive any approval from Citibank.
Silverfern needed to give city the right to decide. If Citibank did not do so within the prescribed period of time, Silverfern was permitted to offer and make outreaches regarding the product to the Equity Club members. But most important,
And that's regardless of the provision that I just read from 1E? that says, in avoidance of any doubt, that you're not to offer anything to an Equity Club member without the approval of a placement agent?
It's in harmony with the timing requirement that's above that. I think what they're saying is you can have outreach with regard to it. Silver Fern did not offer it formally with partnership documents in that regard. They were making outreach, and if you look at the record, that's what provoked this letter to be written, because Citi recognized what they called a loophole in the agreement permitted this to occur, and that's why the letter was sent, in order, in their view, to avoid this occurring. But there's nothing in the record that suggests that anyone felt that Silver Fern's outreach to investors about the RSMA was improper. Contrary to that, all of the email exchanges between...
Your people thought there was something wrong with Citibank sending the letter advising their Equity Club members, we haven't approved this, and...
To clarify...
And if we're looking at this in a context of breach, right, Silver Fern would be in breach first, right, by offering this product without having the approval of a placement agent.
Well, the trial court didn't reach that breach, but the point is the breach is the consent was not... Silver Fern didn't get an option to look at the letter, and that's the breach with the letter.
Well, that's your argument that that's the breach, right? We look at the
course.
contract as a whole. The contract is before the court.
But that breach was not brought by... The trial court doesn't resolve on that grounds. The trial court's breach is distribution fees were not paid. The judgment that was entered against my client was for a wholly separate breach that is subsequent to the letter breach. So I understand if in another case where Citi
All right,
sought a different
I'm
breach...
going to let you do this on rebuttal, because you're eating up your rebuttal time, my friend.
May it please the court, Tom Dewey for Citi. Silver Fern told this court in its brief that Justice Chan's 25-page single-space analysis was, and I quote, cursory and confused. Nothing could be further from the truth. She read the contract, she looked at everything that was in the record, she evaluated the witness testimony.
Counsel, if there's a defined term, right, and that defined term being the investment partnership, do we need to look at the contract as a whole to get a sense of what that term means if it's already defined?
In this case, Justice Chan's opinion repeatedly quotes the actual definition of investment partnership and transactions, which are the individual single-purpose partnerships that are formed to invest in a transaction. So just if I may level set on the structure here, the Equity Club is a club that invests in different deals, right? One of them happens to be Club Med. There's a separate partnership that is set up so that the investors can invest in Club Med, call it Club Med Partnership, right? That's the investment partnership, and that's exactly what Justice Chan said in her opinion. The deal is called a capital T transaction, right? So that is the way this was structured. They then, years later, come up with this totally different structure, the RSMA, right, which was not approved, which was a different structure. So the only thing in the letter is the RSMA is a completely different product.
Did they have the right to offer the RSMA product to Equity Club members, even though it had not gone through the been approved by Citibank, which it had not? He says they could do that. I'm not sure from reading the contract.
So the answer to that is yes, right? Because there's a provision in the agreement that says that Citi can take fees on things that are offered outside of the contract.
So if I understand, basically what's happening here is there are certain investments that Citibank will evaluate and say, yes, we sign off on those, offer those to our Equity Club members, and we will tell our Equity Club members that we agree with this investment and suggest it.
Exactly.
There will be other investments, vehicles created by your adversaries here that you don't agree with, like the case in point.
Exactly.
And under the contract, if I read it correctly, you reserve the right to say, I don't agree with that investment vehicle. I reserve the right to say I am not supporting it or going to sell it to my people. But if you use our list and any of our people invest in it, you got to pay us a fee.
Couldn't have put it better, Your Honor.
Perfect.
That's exactly right.
I
That's
got
right.
it. All right.
Both Justice Sherwood and Justice Chan concluded that there was no violation of what I'll call the preclearance obligation.
Notwithstanding the issue regarding the definition, didn't the trial court make a determination that there were no damages even under that scenario?
Exactly right, Your Honor. They have no case.
Because
they have
that
no
one has
case
not
on
been
causation and damages.
developed yet.
Well, let me just say one thing first, which is that all these deals were offered to all the investors under the equity club, right? So this all has a little bit of an angels on the head of the pin quality, right? You're exactly right, Your Honor, that they could not and did not prove causation and damages because no one paid the slightest attention to the letter, right?
I mean, they didn't know about it apparently for like 2 years.
Silver Fern didn't, but all the investors did. The investors were sent the letter, and guess what? No one
And
paid-
nobody called you, that you said,
Nothing.
please call us?
Nothing.
Apparently nothing.
First deal after the letter was sent, they themselves had said was very well received. Fine, no problem, right? They kept internal records where investors told them the reasons that they declined deals, right? And guess what? Those records don't say anything about Citi. They don't say anything about a letter or RSMA. They say, I don't want to invest in Australia.
And
I don't
even
wanna
if it
invest in
did,
agency." Yes.
would that be a problem?
No, it would not.
What would prevent Citibank as an entity from advising their investors about a relationship that they've introduced them to?
Exactly right, Your Honor, particularly when we don't offer our folks products that are not on our platform, and there's serious regulatory consequences to us if we were to do that, both here and in Asia, which is precisely why the letter was sent, to make it clear this is a different thing. This is an RSMA. It's
With a lot more
Totally. It's
restrictions
investing
you were
in a
concerned
lot of
about.
different things. It's a blind pool. It's not a club. And we, Citi, are not sponsoring this. If you got any questions, call Silver Fern and ask about it.
And the letter, if I recall, was specifically, Citibank seemed to be particularly concerned with the impact of this particular investment and the regulations that exist in China and Singapore, which are much stricter.
Precisely correct, Your Honor. In Asia, they would have needed a license to offer a product like the RSMA because it's a collective investment scheme, to use the Brit framing, right? They didn't have those licenses. So, which is why we said, you can go ahead and meet with the
Violations of those licenses in China are not
very,
dealt with in the
very,
same way
very
that SEC sends you a letter and come in and let's have a meeting. Over there, they arrest you.
Absolutely right, Your Honor, and we do not want that to happen to our people. So it's very clear the pre-clearance obligation.
Didn't the trial court say exactly that to support no causation and damages?
Precisely so, Your Honor. She saw our witnesses. They talked in depth about their knowledge of the regulatory problems. She found them credible. She also gave Silver Fern every opportunity to answer everything and answer the questions. And honestly, their witness backed us up more often than not. For example, he said in his direct testimony that the purpose of the pre-clearance provision was to prevent us from opining on individual deals, right? Because they weren't our deals. We hadn't diligenced them. It wasn't for us to talk about them. The April 2016 letter doesn't talk about any of the individual deals. It doesn't talk about Club Med, et cetera. All it says, as you said, Your Honor, is this is a different deal. We're not sponsoring it. If you got questions about it, call them. So what they're asking this court to conclude, frankly, is that a mutual fund is the same thing as an insurance policy. They absolutely are not. Justice Chan, to your point, Your Honor, had the opportunity to see all the witnesses and read all of the documents, which are often a little bit complicated, and she said that the evidence was absolutely clear that Citi had performed under the agreement.
Thank you.
Thank you very much.
Counsel?
Thank you, Your Honors. If I can just pick up on where that discussion left off. This is a question about whether Citibank needed to get our client's consent before it sent the
Counsel,
letter.
Can you address the issue of causation and damages? The trial court made credibility determinations and found that your experts did not meet the credibility check and found for Citibank.
Yeah, of course, Your Honor. So first, the trial court did not reach damages, but didn't find breach to the extent that its other discussions about Dr. Strackman could be inferred to be a causation analysis. One, we don't believe that was supported by the evidence in the sense that Dr. Strackman ultimately testified that in his industry expertise, he would have believed this letter would be a distancing. City did not bring their experts to trial. They had 2 experts. They didn't bring them. There was no expert testimony against that. But also, Dr. Strubeloff is another damages expert who also opined on what impact that letter would have. You won't see his name in the decision. He testified, his expert was admitted, trial court did not even work or wrestle with his testimony. So to the extent that the court would infer from the discussion about best efforts and the discussion of that gets to somehow damages, there's issues that the trial court did not really engage with Dr. Strubeloff's analysis, and we're missing an expert from City to tell us how an industry institutional would interpret a letter like that. To us, the letter may seem different than what an industry insider would. The important part is the consent requirement, marketing records. These are requirements the parties agreed on. Whether or not the court thinks they are the main focus of this case and it's about regulatory, the real question is, did City need to get clearance before it sent the 2016 letter? And it's whether City needed to produce marketing records. These are obligations the parties agreed on. And the trial court's definition of investment partnership as one offered to equity club members cannot stand under the other provisions of 1E. Thank you, Your Honor.
People versus Jason Washington.
Good afternoon. My name is Hillary Dowling, appearing on behalf of appellant Mr. Washington.
Why don't you bring that mic closer to
Okay. He's a bit taller than me. Mr. Washington was assessed the maximum number of 30 points on the RAI under Factor 1, the use of violence factor, for being armed with a dangerous instrument. Respondent argues for the first time on appeal that a second incident of violence, which would have resulted in fewer points under Factor 1, constitutes a proper basis for an upward departure. This is wrong for several reasons. First, the guidelines expressly contemplate that an offense can involve more than one act of violence, and they instruct directly how the RAI should be scored in that circumstance, by scoring points for the most serious wrongdoing in each category. Because more than one act of violence is expressly accounted for by the guidelines, a second act of violence cannot, in and of itself, form a basis for an upward departure. Second,
this was somewhat of an unusual case because the people did not request an upward departure in this case. Am I correct?
that is correct, and they steadfastly maintained that a level 1 was appropriate throughout the proceedings.
And so the judge, sua sponte, after your first SORA hearing or at the first SORA hearing, said he was considering that and adjourned for a couple weeks to allow both sides to submit briefs to specifically deal with whether or not there should be an upward departure, notwithstanding that nobody had asked for that. Is that what happened?
Correct.
And you put in a brief, but the people did not.
No, because the people maintained that a level 1 adjudication was appropriate.
So but they didn't put in any brief on that issue,
No.
did they? So you put in a brief to explain to the judge why you thought that the level 1 was appropriate and there shouldn't be an upward departure.
Correct.
So, I mean, is it your position that the judge in the first instance even had the right to consider this even though the people had not made a request?
My position, it's the first point in my brief is that under the very particular circumstances of this case that my client's due process rights were violated. Not for notice because he did give me the adjournment, but because—
And he did give you a chance to respond, so—
And did, yes. But specifically that he essentially relieved the people. You know, the people maintained that there were no aggravating circumstances in the record that they could find that would support an upward departure. When the judge adjourned and asked me to submit papers based on the purported factors that he identified, it put Mr. Washington in the position of having the burden shifted to him to prove why an upward departure was not warranted. I'm not taking the position that a judge can never, under any circumstance, under without a motion from either party, consider an upward or downward departure if there is aggravating circumstances in the record to support it. I don't think that that's a blanket rule that's necessarily required, but I think under these circumstances and the unusual facts of this case, that burden was improperly shifted to Mr. Washington to dispel the court of its notion that's stated many times in the record that sex trafficking in general carries a higher risk of recidivism and may always require an upward departure, which is skewed by the guidelines, which said that
Isn't the fact here that there was a second incident that may not have been included in the first factor, where the defendant allegedly punched CR in the face? He then pushed her to the floor and then choked her and pulled her here. And isn't there case law that talks about the violent nature of the underlying offense could give rise to an upward departure?
Yes, there definitely are cases where the level of violence is considered as a basis for an upward departure. Those
Why
rare
not
instances,
here?
but
Why isn't this violent enough?
this is, well, I will first say that the cases where they find that an upward departure is appropriate based on the nature, the degree of the violence are all characterized as egregious, depraved, heinous, really heinous acts that are committed during the course of sexual assaults. And I'm not trying to minimize Mr. Washington's behavior here, but it was the prosecutor, the assigned assistant who prosecuted Mr. Washington's case and was in the best position to assess all of the evidence, even prior to the SORA hearing, who characterized the incident as a misdemeanor assault. Again, I'm not minimizing the conduct, but the DA's own characterization of that assault was, it just simply does not rise to the level of egregious, depraved, and malicious in the cases that I found talking about brutal home invasion, gang rapes, and multiple and severe sexual assaults during a complainant's captivity in a van are a couple of examples. And I just don't think that
Choking a person is not a violent act that would give rise to a heinous type of situation?
I think that has to be considered within the context of him also being assigned the maximum number of 30 points under violence on the RAI, making it very much, the violent nature of his conduct very much accounted for. And I will just add, if I can have a minute, unless you want me to save it, that the count of sex trafficking related to the weapon for which he received 30 points had been previously dismissed by the same court as insufficient. So the only sex trafficking count that Mr. Washington pled guilty was based on that underlying conduct itself. That was why he was convicted of sex trafficking, was based on the assault in the context of his sex trafficking offense. And so I don't think that the very conduct that that led to the conviction, that is the elements of the sex offense that requires him to require as a sex offender, can be transformed into an aggravating factor. It was inherent to the commission.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Bridget White for the people. In this case, briefly, the court did have the authority in this case to sua sponte upwardly depart. There was no burden shift here. Rather, the court put forward the perspective reasons why he was considering an upward departure. This is
Well,
exactly—
the people weren't placed in a position to have to establish a burden, right? Because the court basically sua sponte started the upward departure discussion.
So the people did put forth all of the evidence that the judge relied upon.
Right, but in terms of the upward departure, which is usually the people's burden to prove, the people were not placed in that position to have to meet that burden.
The people didn't advocate for it and thus didn't have to
But that's the point. So you have a judge who clearly thinks this is what should happen. You have the people who are not advocating it, and the judge gets to decide the very thing he's advocating. What's wrong with that picture?
Well, Your Honor, the judge was empowered to do this. There's case law from this department that supports the judge's authority.
So where does that burden go to prove the basis of the upward departure? Who does it rest on if it's not on the people?
It's the burden's on the people to produce the evidence and create the record.
Right, but
the judge then
to establish the upward departure, which is what the judge was essentially advocating for?
Well, Your Honor, in a sense, the judge was putting forth the reasons that he saw based on what the people put forward.
Right, and then
based
the
on
people
evidence.
said, we don't agree with you, Judge. We don't think that there should be an upward departure. So then there's this burden just sort of hanging out there, right? It has to land somewhere. It didn't land on the defendant?
No, Your Honor. The burden was not on the defendant because all he was required to do was put forth, if he chose, evidence to rebut the judge's proposed factors for deviating from the recommendation. And I just want to be clear, we didn't oppose an upward departure. We specifically said we took no position. We didn't feel one was warranted.
But this
it's
taking of no position, right? It always is troubling when you are an entity, you're a party in this action, and you take no position. To take no position is essentially taking a position, right?
I think it's different, Your Honor, here because we never said that the
Especially when you have the burden of establishing the thing that's before the court,
Right. so
and that
what you
being the
just
upward
said is,
departure.
We didn't take a position. It was the judge's call. But Judge, let me help you out and give you all the evidence you need.
But we don't take a position.
How does that seem fair?
Well, the reason I say that is because we never advocated that the factors that the judge relied on were improper, and we never advocated that this was an abuse of discretion, and that still is our position. The judge was empowered to make that determination based on the evidence in the record that the people put forth.
And the people's position is still that an upward departure was not necessary, right?
The people's position is that an upward departure was appropriate in the sense that the judge was permitted.
If he wanted an upward modification, they would have asked for it, correct?
So the people's, let me be very
Wouldn't
clear,
the
sorry.
people have asked for an upward modification, counsel, if they wanted it and believed that it was right?
So what I'm just trying to get across is that we don't believe that the judge abused his discretion here, and there was record evidence.
So you feel that there was clear and convincing evidence, because isn't that there had to be clear and convincing evidence for an upward departure?
Yes, the victim's grand jury testimony provided clear and
So
convincing
there
evidence.
was clear and convincing evidence and the people didn't move for an upward modification, is what you're saying?
We didn't move for an upward modification. Nevertheless, that does not mean that the judge abused his discretion in finding a different result than what the people initially thought.
With the burden on the defendant?
Well, Your Honor, we maintain that the judge did not shift the burden to the defendant because this is the same procedure that would have happened had the people sought the modification because they adjourned to allow the defendant to respond rather than requiring him to prove that he should not be subject to an
And let
upward
me be clear, when they came back with the response, the people still didn't request an upward modification, correct?
That's correct.
Thank you.
Thank you.
All right. Thank you.
I'll be very brief. I just wanted to clarify the record slightly, is that the DA did more than take no position. The DA said multiple times throughout the record that they believed a level 1 was appropriate and that no departure was warranted. And at the second portion of the hearing, after the judge had signaled his the purported aggravating circumstances that he was going to focus on, the DA reiterated that they thought a level 1 was appropriate and actually disagreed at that time with both of the judge's assessments. The DA said, I think that the violence is accounted for by the maximum number of points on the RAI under factor 1, and also disagreed with the judge's analysis with respect to the factor that that respondent has conceded was not an appropriate aggravating factor. If the court has no further questions for me, I ask that you reverse and adjudicate Mr. Washington a level 1 offender consistent with his presumptive risk level on the IAI recommended by the prosecution below and the defense. Thank you.
Thank you.
People versus Karen Agers. You may proceed.
Good afternoon, Your Honors. Michaela Gelman from the Legal Aid Society on behalf of Appellant Karan Agers. Officer Roman's testimony was incredible as a matter of law for 3 reasons. First, His claim that he saw the handgun inside Mr. Agers' fanny pack from over 20 feet away through an elevator shaft across the subway platform while Mr. Agers was sitting in a seat out of his vantage point is implausible at its best and completely impossible at its worst. Second, his failure to turn on his body camera until after Mr. Agers was—
Counsel, before we start talking about those issues, what about the waiver of right to appeal? Does it not foreclose a discussion of these issues?
No, Your Honor. The appeal waiver in this case was not valid because, first of all, the court never confirmed on the record that Mr. Agers had actually read and understood the written appeal waiver before.
But the court went through a waiver allocution with your client, right?
Correct, he did. But
And in that allocution indicated that the suppression issue would not be reviewable based on that waiver.
So this court has held that when the court below does not confirm on the record that the defendant has read, gone over, and understood the written waiver, a court will not uphold that waiver.
Well, that's a different answer from
that's
what
not
my
accurate either.
right, and it's a completely different answer from the question that I posed to you. You remember the question?
So, Your Honor, yes. So the oral colloquy did say that about the suppression decision. However, the overall, this court has to analyze the overall effect.
Precisely. So the court has to take into consideration both the oral colloquy and the written waiver, right?
Correct. And when they conflict, well, a few things. One, when they conflict and when they have omissions that are not fixed by each other, when they can't cure each other.
Well, actually, no, because our case law says that there's no perfect script that needs to be followed so long as the totality of both those things inform the defendant and show the court that it was voluntarily and knowingly and intelligently entered. That's enough.
Correct, Your Honor. And the sum total of the waiver proceedings here was not a clear and understandable waiver proceeding. The court, both the colloquy and the written waiver, omitted the right to information about the right to appellate counsel. The written waiver omitted the fact that Mr. Agers would have had 30 days to file the notice of appeal. And although the court discussed that in the oral colloquy, People v. Shanks has held that that doesn't fix the omission in the written waiver. Additionally, there was discrepancy between which issues survived the waiver to appeal in the written and the oral colloquy. And as I said, in the brief just 6 weeks ago, this court held in People v. Young that kind of discrepancy, that the court then does not fix on the record by confirming that the defendant has read and understood the written waiver. The result of that is confusion between the two, and that's exactly what happened here. So for these reasons, the waiver is invalid, and this court can reach Mr. Agers' substantive claims. So as I was saying, the first reason why Officer Roman's testimony can't be believed is the issue of the sheer implausibility, if not incredibility, of his observation.
Counsel, I thought that besides the 20 feet look, there was also, he was 5 feet away later where he saw a gun sticking out of the defendant's fanny pack. So why wouldn't that be sufficient?
So for two reasons, Your Honor. The first is that all of Roman's testimony about what happens after, as he claims to be approaching Mr. Agers, is based on that first observation from when he's back on the other side of the elevator.
What's wrong with that? So if I'm on the other side of, and I see your client, I think, there's something about that that looks suspicious to me. He can't escalate until he has some confirmation, but something about your client alerted this police officer's observation. So he goes to the other side of the platform, gets on the train, now is approaching. Are you saying that upon his approach, if this officer now sees what is a gun, he can't approach this defendant?
So based on all of Roman's other testimony about his behavior
Is that a yes?
leading up to that,
Oh my God. Is that a yes or no? Can he approach this defendant if, as he's coming on the train to investigate, let me see if what I think I saw from far away is actually what I saw. Now I'm approaching and, oh yeah, that looks like a gun. I can't approach as a police officer.
if what he's saying is to be credited, then when he saw the firearm as he was approaching Mr. Agers, then that could have given him probable cause to continue proceeding. However, the testimony is not credible, not only because of that the issue of the initial moment of observation, but everything that he decides to do after, including failing to turn on his body camera immediately.
Didn't he not turn it on for the safety of everyone on the train? He didn't want to alert the defendant. He didn't want to alert alert anyone?
Well, the officer says that when he first observed the firearm, which would be the moment before he goes up to Mr. Agers, which is when he should have turned on the firearm, turned on the camera in accordance with policy, that is the moment that he should have turned on his body camera, according to the policy. He says that he waited 20 to 30 seconds before approaching Mr. Agers, before he approached Mr. Agers, and nowhere in that 20 to 30 seconds did he turn on his body camera footage. It only happens after Mr. Agers is already handcuffed. But in addition to that, it's not only that, it's also that he did not alert any of the officers in the station, which he could have done by text, by eye contact. He could have continued from where he was standing behind the elevator.
Stop watching the defendant that he saw have a gun, take his eyes off of him, and text his friends and say, hey, buddies, come over. I think this guy has a gun.
Well, he was holding his phone, Your Honor. The officer testified that as part of the plainclothes beat, they are holding their phones, they're in contact with each other. He could have easily done any of those things, including flagging down a MTA employee who he had already seen in the station.
Let's say I agree with you. He could have done any of those things. He didn't. So what?
So this court has held that in cases where police officers' conduct is so inconsistent with what they're claiming
That's the issue, right? The so inconsistent part. Is this conduct so inconsistent with normal conduct that it undermines the credibility of the officer?
So, for example, if I may respond, Your Honor, in People versus Guzman, one of this court's cases, the police officer in that case believed that he had seen a firearm, and instead, which was in a car like across the street. And then in that case, this court held that instead of, or the officer's decision to walk straight up to that defendant alone that he believed was armed without having his own weapon available, this court held that that was incredible. Something similar
That's
happened.
not what happened here, counsel.
Right.
That's not what happened here.
It's distinguishable, right? You're talking about walking up to a car and you don't know what's in the car, who's in the car, as opposed to walking up to a train.
Full of people.
So the train, Your Honor, was not full of people. The surveillance footage
Were
from...
there any people on that train, counsel?
Not on that car, Your Honor. It was just Mr. Agers when the officer approached.
The officer's concern would only be for his own safety.
Yeah, so forget his safety.
No, Your Honor, I mean, that's all the more reason for...
No, I'm not, I'm saying that because there were no people on the train, the officer can completely focus on just your client and keep his eyes on him. He's not distracted by other concerns.
Well, Your Honor, I think that the foundation that the officer is using for that approach is the concern also for, he talks about when the train is going to go to a different station. So he is also talking about, what could happen in the future, if that's what Your Honor is referring to. So for those reasons and the rest of his testimony being so inconsistent and full of inconsistencies, we're asking that this court reverse the suppression decision and dismiss the indictment. Thank you.
Good afternoon, Your Honors, and may it please the court. Samuel Goldfein on behalf of the people. At the outset, as Your Honors recognize, defendant validly waived his right to appeal. This is, quite frankly, one of the best, if not the best, waiver colloquy I've ever encountered. The judge made clear that it was separate and distinct. He made clear that he described the right to appeal. He described the manner in which defendant could take an appeal. Defendant was offered, in this case, the option between two pleas, one of which included a waiver and one of which did not, and he elected the one with the waiver.
Was he told that he would retain a right to counsel for the appeal if he couldn't afford one?
No, Your Honor, the judge did not inform him of that.
So not the best, right?
Well, I respectfully, Your Honor, it's not perfect. One time I said textbook, and no one has given the CJI charge ever, and certainly this is not the CJI charge. I'm not suggesting it is, but it was an incredibly thorough waiver. And on top of that, defendant was expressly advised and stated that he understood that he was giving up the very claims that he raises here today, challenges to the suppression ruling and challenges to the length of his otherwise lawful sentence. I'll turn briefly to the arrest. This was a fairly routine observation of police officers working in plain clothes on a subway platform. He observed defendant. Defendant piqued his curiosity. He focused on defendant. From 20 feet away, he saw defendant unzip his fanny pack, revealing a gun, a separate magazine, and a bullet. And then the officer walked onto the train. He's in plain clothes from 20 feet away, 15, 5, all the way up to the door of the subway, to the seat across from the door. He sees defendant in possession of a gun.
How do you handle your opposing counsel's claim that the officer's testimony was so improbable as a matter of law to undermine the officer's credibility?
With all due respect, Your Honor, I don't think anything about his testimony is incredible. You can see a shiny gun from 20 feet away. You can certainly see it from 5.
What about when he reaches to the train and he doesn't alert any of the other officers with him that there's an issue?
And he didn't turn on
Anyway.
the body camera.
Yes, Your Honor.
And to me, that is the most troubling fact, because you're on a train at 2:45 in the morning, you believe this guy has a gun, and you don't call for backup?
Your Honor, the judge credited.
That makes no sense.
I take Your Honor's point. The judge credited the officer's testimony that he calculated his decisions under the circumstances, and that was what he decided his best option was. He was worried that the train would leave the station, which it does with minimal warning. He was worried about being trapped on the train until the next station with defendant, who he believed was armed with a gun, and he did not want to escalate the situation by shouting for backup.
Part of the problem also, too, is because he didn't turn on his body-worn camera. We don't know what happened leading up to it.
Well,
we
Your
don't
Honor,
know what he saw. And then the other body-worn camera footage that we saw, it's upside down, it's sort of obscured, you can't really see what's happening.
Yes, Your Honor. The body-worn camera is certainly of limited utility. I'm not going to suggest otherwise. But his testimony is largely corroborated by other evidence. It's not just his testimony. The body-worn camera, what it does show and what it does capture is that the fanny pack was open. We see when an officer Gosevic hands it to Roman that stuff falls out. We don't see the objects fall, but we can hear them hit the platform. The platform camera corroborates other portions of the officer's testimony, like the fact that he had a struggle with defendant. Defendant pulled him back onto the train while they were struggling. So his testimony is corroborated. The court credited his testimony, got to observe the officer testify. And if there are no further questions, I would ask that you affirm.
Thank you.
Thank you.
You have a minute.
All right, just a few quick points, Your Honor. First is the idea about the waiver being thorough. This court has held in Arizona that the oral colloquy being thorough is not enough. It has to be correct. Second, I'd like to move on to some of the points just raised about the record. All of Roman's behavior undermines the series of observations that he said, the entirety of his approach to Mr. Agers. As you can see in the surveillance footage, there is another officer present in the surveillance footage the entire time that Officer Roman never alerted. The lack of body camera footage, as this court is concerned about, courts have held, including appellate divisions, have held that that undermines an officer's credibility when considering the entirety of their narrative. The prosecution mentioned that you can hear an object falling out of the fanny pack. That is obscured by the video footage. We cannot see that. And in fact, the part you can see on the body camera footage shows the bag being open upside down with nothing coming out of it. And finally, the prosecution's claim that there was a struggle between Mr. Agers and the officer is really undermined by the surveillance footage, if Your Honor, which I know Your Honors have seen. The entire tone of the interaction that the officer is trying to paint here is really belied by the body camera footage. Excuse me, the surveillance footage. Thank you, Your Honors.
Thank you so much. Silva Rios versus New York Presbyterian Columbia. Justice Rosado is recused. Should there be a tie, the court will follow its AD1 rules in that regard. You may proceed.
Good afternoon, Your Honors. May it please the court. Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in granting the defendant's 3211A7 dismissal motion based upon the affirmative defense of EDTPA immunity. As in Holder and Jackson, defendants have failed to conclusively establish that all of plaintiff's treatment over the course of 4 full months was impacted by defendant's response to the pandemic. We submit respectfully.
This treatment happened during the height of the pandemic, right?
That's correct, Your Honor, for a 4-month period between March and July of 2020.
And your client had to be placed on a ventilator to save her life.
That's correct, Your Honor. There's no question about it that she was a sick woman and fortunate to be alive, but that does not excuse under the
During the time that she was in the hospital, she was on the respirator for that entire period, right?
That's correct, Your Honor. Yeah. And you know, under the circumstances, as this court did in both Holder and Jackson, we differentiate the theory of malpractice, the theory of liability, from
Holder and Jackson. Were they in a different posture, so to speak? Were we looking at facts or looking at the issue prior to having any real discovery?
They were all 3211A7 motions. There may not have been, pardon me, Your Honor?
So yes.
Well, this case is also 3211A7,
But it's
there was
also
a significant amount of discovery.
it's also a 3212.
The award of the order, I
It
believe, is
moved under
only-
both.
Pardon, Mark?
The motion was under both sections.
Right, but the order was only under
I understand, but
3211A7.
But the posture of it was after discovery, right?
That's correct, Your Honor, yes. And, you know, what happened in discovery, frankly, is the reason why we don't just blindly accept affidavits when it comes time to decide a 3211A7 motion. Because here, when we look at what this, the nurse, the wound care specialist actually testified to, it actually undercuts the general allegations of operational changes and short staffing that's in her affidavit.
How so?
Because if you look at what she actually testifies to, it's clear that what's contained in the affidavit is not based upon any knowledge that she has other than the general operational changes. And I'm referring specifically to page 356 in the record, for example. Two questions that are posed to her that pretty much go right to the heart of why you can't accept an affidavit on a 3211-7 motion based upon evidentiary material. So at page 356, the question's asked, this is of the hospital, right? Were they having staffing problems with repositioning the patients every now and then? Answer, it is possible, but I was not there to see that necessarily. So she's testifying in a way that completely undercuts any notion that these general operational changes or general short staffing actually impacted this individual.
During the height of COVID, we could say anything was really general, right?
Well, they're talking about operational.
We had to bring in trucks to put bodies in.
That's true.
Okay, so there's no question that in March of 2020, we were at the height.
That's
we were at the beginning. We were losing thousands.
That's all true.
Okay?
That's all true.
So,
but here it only begins in March, and there's a 4-month arc of
and it
of
got
this
better.
woman's.
It got better from March to July.
It certainly got better than in March. I mean, I agree with you that this was the height.
I don't know that. What I recall is shortage of PPPs, right, or PPEs. I forget the acronyms now. It was
a
insanity.
dark time. It was a dark
complete
time.
insanity.
No question about it, Your Honor.
Okay,
No
and
question
we
about
know
it.
this. So I mean, we can't operate in a vacuum and pretend like what it was isn't what it was.
That's true. But in Jackson and Holder, this is also during that time period, during a time of COVID. And this court is able to and has differentiated and separated and compartmentalized the concept that this is a bad time, this is a dark time, and the hospital had to undergo changes to accommodate this dark, bad time, and what the actual allegations of negligence, malpractice are. And I see that my time is up. So I think that is the lesson from Holder and from Jackson, that this court will compartmentalize and differentiate. This is not a COVID injury case. This is a case that stems from an initial diagnosis of COVID, just like in Jackson, I might add, and it continues over the course of 4 months. And the second question—
Over the 4 months, she's on the respirator being treated based on COVID.
That's correct.
Not because of other underlying conditions.
That's correct, Your Honor. Well, there are other underlying conditions, but yes, essentially that is correct. But that does not—
So she's being treated for COVID. I don't understand your argument.
Okay, so Jackson, the person was being treated for COVID and tripped and fell and hurt themselves on the way to the
and
bathroom.
we don't have that here. So that is not this situation, right?
But it's a person that was being treated for COVID, just like this is a person that was being treated for COVID, right? And so when we look at what the EDTPA immunity requires, and we haven't even talked about what's in Holder about how it's supposed to be strictly construed and how the evidence has to conclusively establish the defense. We haven't talked about that yet. But what Holder and Jackson stand for is that in a situation where the theories of malpractice are not predicated upon the contraction of COVID, but upon other things like a failure to reposition, like a failure to treat horrific pressure sores, excuse me, that will look to whether or not the pandemic and the response to the pandemic impacted upon that treatment. Not the treatment for COVID, but on that treatment.
All right.
And that's exactly what the court said in Jackson.
Thank you. You'll
Thank
have
you, Your
time
Honor.
on rebuttal.
Good afternoon, Your Honors. May it please the court, Barbara Goldberg for the defendant respondent. I would like to point out that there are key distinctions between this case and Holder and Jackson.
I'd like to focus on what the evidence in this case shows or doesn't show.
Okay,
So tell me specifically, where in the record do we have any information about what was actually done for this patient vis-a-vis these sores? Because I see nothing, so maybe I missed it. Tell me what page, what document.
We do have the affidavit of Lisa Cullinan,
and where in that affidavit does she tell us what was actually done for this patient?
she says-
Counsel, I need to finish my sentences before you can answer them.
I apologize.
Okay? So what was actually done to address the sores? Where, because all I saw was generalities. I want to know specifically, what did they do with respect to noticing those sores?
Well, they did apply various creams. They put her on an air tap bed, which was a special bed. They ordered a Citadel bed, which was a bed that was reserved for patients who had stage 3 ulcers or more.
So, all right, stop there. So they ordered the bed for someone with stage 3 ulcers, which tells me that this patient went through stage 1 and stage 2 without any treatment. So tell me what in the record explains what was actually done for this woman who was, I believe, only 47 years old?
That's correct.
Right? And she contracts this horrific disease, right? And she's on a ventilator and she can't move. So she is relying on the hospital to do what every hospital knows has to be done with somebody who's bedridden, which is change their position every 1 to 2 hours so the skin does not break down.
Well, those orders were recommended by Nurse Cullinan, but I would like to move on to...
No, I need you to answer my question.
All right, Nurse Cullinan did recommend turning and positioning at 2-hour intervals. It's not documented in the record that that was done, but I think that it's important to remember that under Executive Order 202.10, record-keeping requirements were suspended during this time period.
Counsel, if it's unclear from the record how often plaintiff was actually turned and repositioned, how can we determine a matter of law that the alleged deviation from the standard of care was pandemic-related, which is the ETPA?
Well, I think, Your Honor, that what the ETPA requires is that the treatment of the patient be impacted by the pandemic or the response to the pandemic, and it does...
If we don't know what the treatment was, how can we know it was impacted? That's my whole point.
So I think we know that it was impacted through the deposition testimony and the affidavit of Nurse Cullinan, because...
As my colleague said, what was done for the patient during the course of stage 1 and stage 2, so this court can understand what the standard of care is and how it's related to the pandemic?
As I said, Your Honor, the patient was given the air tap bed. She was given the...
I'm talking about repositioning and turning, because that obviously causes the sores. If you don't reposition and turn the patient, as the expert stated, that will occur, and it did occur in this case.
The expert, Dr. Wolf-Klein, stated that when a patient is on a ventilator and has all of these serious conditions stemming from COVID, if you turn and position them the way you would someone else, you risk the patient becoming severely destabilized and possibly...
Isn't that expert decision controverted by the plaintiff's expert stating you could do that. That would be a question of fact.
The plaintiff's expert didn't really demonstrate any familiarity with hospital practice in New York. He was from Maryland. He was not.
That goes to the weight of the evidence,
Right,
but
but-
certainly there was an opinion that was given.
Right, but I don't think that expert was.
Let's assume for argument's sake that the expert's fine. Wouldn't that be controverted?
I'm sorry, could you say that?
Let's assume for argument's sake that the expert is sufficient. Wouldn't that be a controverted issue as to whether or not the two experts have an expert battle as to whether you can position a person on a ventilator?
But that doesn't really address the issue of the applicability of the EDTPA, Your Honor, with all due respect, because the EDTPA just requires that the care of the patient be impacted by the facility's response.
If we don't know what the care was, how do we know that it was impacted?
I think we know that there was impact because Nurse Cullinan specifically testified to, she was familiar with the critical care unit where this patient was housed, and she...
Isn't it true that on page 356, as your colleague just mentioned, that she was not present most of the time? She would not know that?
She saw the patient 7 times, and she was certainly...
6 times, but okay.
I thought she said 7, but at least... I'll put it this way.
7, it doesn't matter.
At least
Go ahead.
6, but I want to call the court's attention to her testimony on page 340 of the record. And she was describing what was going on during this unprecedented time, which I think we all agree, and I think we all remember it. And she said, it was a very unprecedented time. It was a horrific time to be a nurse. We were severely understaffed. We had lots of issues with supplies and getting PPE, personal protective equipment, in order for us to go into the room. Masks and gowns and things like that were limited at the time. We had many challenges during that time. And she also testified how donning and doffing the PPE limited the time that could be spent with patients. There was a shortage of wound care nurses because they were assigned to other positions. There was a shortage of supplies. So overall, the treatment of this patient was impacted because the nurses just couldn't spend as much time with her as they would have done otherwise. And I think it's important to point out that even her husband testified at one point that he was actually, interestingly, he was an employee of another NYPH facility, the Allen Pavilion, and he testified that basically he was told by the staff at NYPH Columbia that they were learning as they were going because treating COVID patients was a, quote, new thing for everyone. That's at page 438 of the record. He was unable to...
We got it.
There was an impact. There was definitely an impact on the care, Your Honors. And thank you for letting me go beyond my time.
No problem.
Very briefly, Your Honors, I'd just like to pick up on that deposition testimony. So at page 356, was the hospital having staffing problems with repositioning the patients every now and then? Answer, it is possible, but I was not there to see that necessarily. Next question, after you make the recommendation, talking about repositioning now, is there any way to tell by examining the patient whether the repositioning had been done on a regular basis? Answer, there is no way for me to tell for sure. I would just know the patient was turned when I came into the room. So that's 6 times over the course of 4 months.
What
And then we
about the
jump-
part of the affidavit where the nurse does in fact say that the shortages kept them from being able to go into the room every 1 to 2 hours because they were just short manpower?
Again,
And short PPEs, because under the hospital's protocol, they could not go from one patient's room with one PPE. They had to take that off, put on a new PPE to go into another patient's room, and do that repeatedly. And we had a shortage, so they could not continually take off, put on, take off, put on.
But that doesn't excuse. But that doesn't excuse 6 times over 4 months, Your Honor. And we have no.
We
way of
don't
knowing.
know that because
We
there
don't know that.
We don't know that it was only 6 times.
No.
Because
It's
they
not
did it
documented, right?
Precisely.
Yeah.
So your statement, 4 months only 6 times, is disingenuous because we don't know.
We don't, but that's what the record reflects. We know what the record
That's
reflects.
what's documented.
And so at page 358, the question is, do the notes indicate whether there was any difficulty for the hospital staff to comply with the recommendation? Answer, no, there is no indication of that. Page 359 of the record, is there any indication whether your recommendations were not followed? No, there is no indication that it was not followed. So the record is just barren of what exactly was done. The only thing the record does indicate for sure is that the patient was turned 6 times in 4 months. That's the only thing that's indicated for sure, and that's by virtue of that testimony. And again, this testimony, just to emphasize again, is precisely the reason why we don't accept affidavits, certainly conclusory affidavits on 3211A7, and endorse a judgment as a matter of...
We do accept them on 3212, right?
And this is both. Thank you.
Thank you, Your Honor.
HNA Holdings versus TSCE 2007.
Good afternoon, Your Honors. May it please the court, my name is Robert Weigel, and I represent the defendant, TSCE, which is a Tishman Speyer entity. This is a contract interpretation case. The facts are not contested, and there's really no dispute that HNA, which was a huge Chinese conglomerate, number 170 on the Fortune 500, $171 billion worth of assets, defaulted on its payment obligations. Tishman and HNA agreed to develop a building in Brooklyn. They'd done this before in Hudson Yards. There were 2 structures, and I was going to show it to Your Honors, but I think I will spare your eyes. But Tishman puts up $50 million in one side. HNA puts up $200 million on the other. They then invest in a downstream entity. The building's supposed to cost $500 million. Tishman is going to put up $50 million. HNA is putting up $200 million. They're going to borrow the rest. And it's an estimate, of course. It's construction. So in the middle of construction, in September of 2017, the building is not built yet. It's in the middle of construction. It doesn't top out until almost a year later. They stop funding. There's no assertion that HNA doesn't have any money. They're still a huge conglomerate. They do go bankrupt in 2021, but that's 4 years later. They just simply had a desire. They had other priorities, so they don't fund their $37 million that they're obliged to fund.
So does that constitute a breach?
Absolutely, Your Honor. It does after they were given notice and a time to cure, and then a second time to cure, and they did not cure it. And throughout 2018, Tishman's left with a position where it either has to abandon the project or it has to somehow get the basis to fund it.
So okay, so how do they get the funding? It seemed that there was like a provision for like a default funder.
Yes,
I may be saying that wrong.
An option, but not a requirement, for the Tishman entity to advance the money at a 20% interest rate. Instead of abandoning the project, they choose to do that. So Tishman advances the money, and it's advanced and it stays out there. In 2019, there is a settlement. Tishman agrees to buy one of the other buildings from HNA, and they agree that HNA will pay off these default loans at a reduced interest rate. We cut the interest rate to 10% because we're not doing this to make money on a default loan. It's at 10%, so we agreed to do that. They then don't fund anything after that. They have blown up the business plan because the business plan from the start...
Counsel, can I interrupt you? Can we really get into the LPA? Because we all read the history, so I really want to get into the contract.
Sure, certainly, Your Honor.
So there are 2 provisions. You have 3.022E, and then you have 601E as well. So let's call it the penalty provision and the major decisions provision, which has been defined terms. So explain to me the difference between the wording herein and in the agreement. That's really the parsing of the words. And explain to me why one word herein means in the agreement or means in that section of 3.02 or something else. Let me hear your explanation about the interpretation of those two provisions?
Certainly, Your Honor. Herein is used throughout the contract to mean exactly what it means, throughout the contract. And you can see that if you just look.
Isn't that not true? Because I looked and I saw it used different ways. Let's say net cash. It says net cash. It says herein, and the definition of net cash was within that provision. I could give you at least a number of situations where herein refer to the particular section, but you're correct. At the very beginning of the whereas section.
Yes, right. It's in
talks
the very
about-
beginning.
and
It
you
says in
pointed it out.
consideration
Correct.
of the premises and the mutual agreements herein.
Isn't it true that herein's being used in two different ways? It's being used as referring to a particular section and in the agreement.
Yes, but there's no reason to believe that in this section, in 302, that there is any other approval right that's being taken from them. It doesn't make any sense in that context.
Okay, can I ask you a question regarding 302E as well?
Yes.
Isn't there the words herein in the agreement in the same section?
Yes. 302E says very plainly, let me see if I can get it here.
Notwithstanding anything herein to the contrary?
Right.
And then if you
uses
look
the
at
word
little I,
right? Notwithstanding anything in herein to the contrary, if a non-funding partner fails to contribute its required share of any mandatory capital contribution, then such non-funding partner shall permanently lose all of its rights, if any, to vote or approve any matter that would otherwise require its approval pursuant to this agreement. It is clearly meant to apply to the entire agreement, and that's the only way that the agreement makes sense when you mentioned one of the earlier appeals about looking at it as a whole.
How does that interact with the major decisions provision, which is in 6.01E, which starts notwithstanding anything to the contrary contained in this agreement?
Your Honor, there definitely is tension between those two.
Yes, definitely.
This is probably not the first contract where there has ever been tension. In fact, that's why there are rules. This is a Delaware law contract, but there are rules as to how you evaluate and deal with those. And the basic rule that everybody agrees to is that the specific governs the general. The specific is deemed to be an exception to the general.
So which is the specific in your opinion?
In my opinion, the default situation is a specific situation. Ordinarily, if they're doing what they're supposed to be doing and the contract is moving along and they're not breaching the agreement, then they have a right to approve major decisions, right? They're putting up their money. They have a right to say you can do it or not.
I mean, they're putting up 99.8% of the
In the partnership,
partnership.
One side, the other side, we are putting up
Okay.
20%. So we are putting up $50 million. It's not like we don't have money in this.
Okay.
So what you've got here is a situation where they have an obligation to fund. If they don't fund, then they lose their right to.
So let's cut to the chase here. So they are the big equity partner in this deal, right? The whole reason why H&A is in this deal is to provide the capital.
Absolutely. We have the expertise. Tishman builds buildings.
Right.
They
So
have the money.
your side, under the contract, had exclusive right to the management, et cetera, except for these 21 items in the major decisions provision, correct?
Yes, so long as they're
And
not.
the contract also said you have a right to have a say in those 21 items so long as you pay, right? So you have to fund. If you don't fund any capital call that is asked, then you lose your rights to sit on the board and to engage in major decisions because that's what the board does.
Yes.
Am I wrong? What does this board do but consider this deal and how to move forward?
That is all that board does.
That's it, because that board was created specifically for this deal and for this transaction.
Your Honor, you're absolutely right, and this is the rule that applies throughout life, which is that if you're putting up your money, you get a say, and if you don't, it's the same rule with my kids, right? If I'm taking out, I'm paying, I get to decide.
Right.
If they're paying, they can do it, you know? I mean, they have a say. But when they stop paying,
So what they want, their argument basically is, okay, so we didn't pay, we didn't do what we were supposed to do. But we should still be able to sit at the table and force you to get out of the mess that we put you in by not putting up the equity. And we get to have a say in how you do it.
That's exactly right, Your Honor. And that's what, I see my time's up.
You'll have time on your brother.
Good afternoon, Your Honor. May it please the court. I'm Carl Oberdier for the plaintiffs and the respondents. It's important.
How do you not abide by your part of the deal, which is the only thing you have to do is put up the money? You don't put up the money, but you think you're still entitled to be able to have a say in what happens, as the other side now has to dig themselves out so they don't lose their $50 million and everything they've invested.
Your Honor, I could see the equity in your point if we had never put up the money, but we did. We fully fulfilled.
No, you didn't fully put it in.
We did,
You
Your Honor.
defaulted.
Your Honor, we later fully
Yes,
put it
but
in.
you defaulted first. So we got to deal with that first, right?
Yes.
Right. So what are the consequences under the contract of you defaulting on a capital call?
Well, as Your Honor mentioned, a separate consequence, not the one that we're dealing with here, is that we did lose our board seat. But remember, the board seat...
What does the board do? As I just discussed, because we're not going to play this game. The board here does one thing. They have one objective in this board. It's build that building so that we could get our investment dollars back. That's it. It's real simple. So you did not fully fund. You violated and you defaulted on a capital call, so you lose your rights. The agreement says any rights.
Your Honor,
Any.
Your Honor, we were not a member of the board of the partnership. We were a member of the board of the REIT, and I respectfully disagree that all it does is make major decisions. In fact, it never makes major decisions.
What else does this REIT board do?
It manages the day-to-day work of the project.
No, a board doesn't manage the day-to-day operations of a company. That's not true.
Your Honor, it
That is
oversees
the antithesis of what a board does.
I think there's a grave misconception of what a major decision is. A major decision is tearing up the LPA and rewriting it. It is expressly, one of the enumerated major decisions is breaking the law. The board is not supposed to break the law. Another enumerated major decision is breaching the LPA. The board is not supposed to breach the LPA. Another major decision
You're right.
is changing
Except
the
that-
business purpose.
Except that when you breach in the first instance, then there are consequences. And you are talking about everything you have just described fell from the consequences of your client's breach
Your Honor,
and your client's default.
there are 13 different rights of approval that H&A has under the LPA that are not prefaced with notwithstanding anything to the contrary in this agreement. We would concede that we lost all 13 of them, and I'm happy to read them into the record. But the major decisions are
You covered that in
apart.
your brief, so I don't need you to read
The major decisions are completely apart. The major decisions are rewriting the deal, in this case, to Tishman's benefit and our detriment, after we had paid all of our $200 million commitment, because they had lost, and let's make sure.
But what were the contribution calls that came after that you did not fund? I mean, that's how the default happened, wasn't it? There were contribution calls?
There were.
After the 200 million.
But the problem is the 200 million is a cap. We have a contractual right not to put in more than 200 million. So what they said was, because 2 years ago you were late in putting in your 200 million, although you ultimately put it in, now we're going to say you owe $35 million more, which we had told them we could not pay. And they said, well, we've got an option to get third-party financing, but we actually like this deal where we force you to default. This is in the record. We force you to default because then we get the 20% interest. And since we're worried that this deal that we're pursuing is going to backfire, We really want that 20% interest as a backstop so we can recover our losses if and when that happens. That's all in the record. That's what they did.
What they did was they had a contractual provision that anticipated that there might be a default. And so they had a provision that created a vehicle by which they could get past that hump. That was in the contract.
Third-party financing was the
That
vehicle.
was in the deal.
I'm not sure which provision you're referring to, Your Honor. The deal, if you're talking about Section 3.02E, specifically says, notwithstanding anything herein. Now, Mr. Weigel says that that doesn't, make sense because there's nothing to the contrary herein in Section 3.02. Oh, but there is. Right above in Section 3.02D, the LPA says that if there is a default and if there is a default loan, the default loan will be deemed for all purposes under this agreement to be a capital contribution by H&A. Now, if you took that provision and said, oh, well, then they issued a default loan, that means we made a capital contribution, why then you can't apply 3.02E, can you? Because there's been no default, because we've made the capital contribution. Now, we don't have to argue that.
5.01E talks about in repayment of a default loan.
Yes.
Okay, so
But
we've read these papers, sir.
Yes, Your Honor, I'm sure you have. I'm just saying that there is a conflict between 3.02E and 3.02D, or at least an arguable contract, that is resolved by having that interest section notwithstanding clause in 3.02E. But what do you do with the clearly global notwithstanding clause in 6.01E that says notwithstanding anything to the contrary in this agreement?
You know what? 3.02E also has that very same language if you go all the way down to the bottom. It also says the same exact language of notwithstanding anything to the contrary contained in the agreement. And that language is in 302E.
But not in the clause we're talking about.
It is in 302E.
But not
the entire body of it.
At the bottom.
Yes, at the bottom. Read it. Take a look.
Oh, I did, Your Honor. I did.
Yep.
But all that means is that they used it where they meant it at the bottom and they didn't mean it at the top. What about section 6.08C, where it also starts with notwithstanding anything to the contrary in this agreement? But there...
And there it said, provided that so long as the plaintiffs have not lost this right under section 3.02E.
Yes, Your Honor, and that, as Justice Cohen said, that shows that when they meant to make a notwithstanding anything in this agreement clause subordinate to 3.02E, they said it. And the fact that they didn't say it in 6.01E means they didn't mean it. That's just basic contract construction, at least in Delaware.
Which section's more specific?
I'm sure that wasn't a disrespectful statement.
It wasn't, Your Honor, I
Lord,
promise.
I'm so glad.
But the more specific, I think if you're doing a column, 3.02E, 6.02E, the more specific is a wash. The reason it's a wash is that, yes, it is more specific, as Mr. Weigel says, when you're talking about the circumstances that trigger it, but you have 21 enumerated, very express, huge decisions that are very specific compared to 3.02E, which says rights to approve anything you have, if any, in this agreement. That's not specific. So the subject matter of 6.02E is much more specific. It says, you want to do this particular enumerated thing, you have to have H&A's consent.
Thank you. You have 2 minutes, sir.
I just want to make one quick point, which is that Justice Cap is correct that they again failed to fund in December of 2019. And there was a $10 million capital call. It was needed to go forward. They didn't fund that one either. That was clearly within a development budget. And they weren't going to fund going forward anything. And there was money that was needed to develop this building. And so we picked this Whittle School, and I listened with horror at the last argument because we signed this deal with the school in January of 2020. They put up a $52 $43 million letter of credit, and then
Pandemic.
COVID happened 6 weeks later, and the school doesn't happen. But people were fleeing New York. Nobody was looking to get their kid into a new school. I mean, you can't have it. Nothing my colleague here has said in any way contradicts the basic economics of this deal, which is that they cannot be driving the bus if they're not putting up their own money, and they can't dictate how Tishman has to put up money if they're not going to fund it themselves. Thank you, Your Honor.
And that's a reading as per Delaware law too, right?
Yes, this is all Delaware law. Yes, Your Honor.
Matter of Liam.
You may proceed.
Good afternoon, and may it please the court, David Chalik Klein on behalf of the non-respondent mother, Sasha C. The question before this court is whether the family court issued unconstitutional orders that authorized armed sheriffs to search Miss C's home and interrogate her children at school. ACS asked this court not to address that urgent question because the answer will stop the agency from operating on the foundational premise that uncharged survivors of domestic violence are denied the presumption of fitness and deserve only diminished Fourth Amendment protections equivalent to people on parole. These principles shape the agency's daily actions, and as the many amici highlight, impose enormous harm on children, survivors of domestic violence, and families. This court should put an end to that widespread practice. Starting with the Fourth Amendment, Your Honor, there were a number of orders that were issued throughout this case that said plainly, ACS supervision, including household monitoring. I cannot imagine an order that is more non-specific and unbounded that. And under bedrock Fourth Amendment law, a home search order has to leave nothing to the discretion of the executive branch agents. Here, those orders left everything to the discretion of the executive branch agents. And what we saw is how they exercised this is sending ACS caseworkers to search a survivor of domestic violence home to ask them, to force them, not ask them, to force them to leave visiting their grandmother who was sick with cancer to come back, forcing them to leave a child's soccer game to come back, sending armed sheriffs in Florida to the children's school and sending armed sheriffs to the family's home on Christmas. This is a...
Was the New York order ever registered in Florida, if you know?
Meaning the order of protection?
The order of disposition, any order. Were any orders from New York Family Court registered or domesticated in Florida?
There's nothing in the record on that front, Your Honor. What I do know just from practice is when non-respondent parents are with children out of state, ACS uses out-of-state government officials to help carry out their supervision orders. And the problem here is that ACS had the discretion to impose its supervision as it saw fit against somebody who was never charged with any wrongdoing whatsoever.
Counsel, can we find that pursuant to Family Court Act 1054 that this was the order was unlawful just based on the provision of the statute?
We don't think that the language in Section 1054 is as clear-cut as in Section 1017, which is a predispositional statute, which is what this court's decision was based on in matter of AR, which was a follow-on from the Second Department's decision in matter of Sapphire W. The language in that statute was when a child has been removed from when a court orders the removal of a child from his or her home.
There was no removal here.
There was no removal. That language, however, is absent in Section 1054. So we think, just like this court did in matter of FW, when Your Honor was on the panel that reached the constitutional issue, that the court must reach the constitutional issues here. And it wasn't just a clear violation of the Fourth Amendment. And let me just emphasize one point, which is that the family court is not unfamiliar with concepts of probable cause and particularity. When ACS wants to search the home of somebody who it is investigating for and is suspected of mistreating their children, they have to go to family court, ask for a 1034 order, and what do they need to show? Probable cause and particularity. In fact, it is the exact same procedure which is in the search warrant under the criminal procedure law. The problem is that either the family court didn't know that it had to follow the Fourth Amendment here, or either it didn't know or it did know and simply did not follow the requirements of conducting a searching inquiry. And there's no burden. Can I finish, Your Honor? Yes. It is bedrock Fourth Amendment law that the government has the burden of putting forward predicate facts to establish probable cause, and it is the issuing judge's non-delegable duty to do a searching inquiry to establish a probable cause. And while sometimes that is giving deference on appeal, it is only when there's been a full searching inquiry that established the operative facts. And when the family court asked ACS, why are you looking to continue supervision of the mother? Their answer, because the father has not completed his services, who is living 1,300
So the
miles away.
matterer doesn't do what he's supposed to do. So let's punish his wife who was the abused. This is just despicable.
That's absolutely right, Judge. And the same rationale that was being used 20 years ago before the landmark case, Nicholson, which went through the district court, the Second Circuit, and then the New York Court of Appeals for Nicholson v. Scopetta, are the exact same rationales that ACS is recycling in front of this court in order to surveil survivors and their children.
All right, thank you.
Thank you.
We'll have time on rebuttal.
Good afternoon, Your Honors. Sal Zipkin, Bronx Defenders for the respondent father. May it please the court. Most importantly, we support the appellant and their arguments and everything. I just wanted to add a couple points. First, I want to address Your Honor's point, which is that I hear you, I understand. My client did not contest the very troubling allegations here, did not seek to go to trial, and I'm not here to minimize or contest them or anything like that. But what I want to say is the nature of how Article 10 works is that there is the finding of neglect, and then the family, there's a dispositional stage, and the family moves towards reunification. And that's what's happening here. Post the finding, during the dispositional period, the father and the mother certainly have had a very positive co-parenting relationship. The father has a very good and strong relationship with the children, speaking to them.
In fact, she says he's a good father.
Yes, she testified that he loves the children. They bring the iPad to the soccer game so he can see. He talks to them, I think the testimony was an hour a day. And so whatever happened and led to the neglect finding is serious, and also we're moving towards the reunification here. And why I bring that up is because in deciding, again, in the way appellant argues this case, this appeal, we want to flag or call attention to the fact that the rights and interests of the respondent and non-respondent parents are intertwined. And so connecting to your Honor's question about 1054 earlier, one of the things that I think is particularly important is that in terms of appellant's arguments that the supervision orders here violated the Fourth Amendment and due process parental rights, we would hope that the court's eventual decision will say that, that those are unconstitutional, but there not be something we've seen potential examples of in the family court, which is that courts will read that to say no orders can be issued regarding the non-respondent parent. And why that's relevant is because 1054 includes the provision that the court can issue orders that the non-respondent parent cooperate in visitation and facilitating visitation. Again, that's not an issue in this case. We have no complaints about the nature of the relationship and the
So
way
what is
that's
your
worked.
position? Should we find that it's partially unconstitutional and save the parts that benefit your client?
You should find that as applied here in the circumstances brought in this case, it's unconstitutional, and the parts of the statute that don't raise Fourth Amendment or due process parental rights concerns like the court's ability to order, and it's not going to need to in every case, but ability to order that, that the other parent, the non-respondent parent, cooperate in facilitating visitation, that not be found unconstitutional, that in cases where, again, it's not as positive as here, where the other parent.
I don't think that there was a complaint here by the mother about facilitating interaction between the father and these children.
It was not. She, in fact.
The issue here is that this woman has done nothing wrong, but she's being treated like a criminal. And her children are being re-traumatized again and again. That's the issue here. And that's going to be put to a stop.
I agree with you, Honor. Thank you very much.
Good afternoon. May it please the court, the Legal Aid Society by Zoe Allen for the children. I would love to answer the question about whether that reading of the statute of Section 1054 and Section 1052, which refers to it, is constitutional as applied, and I feel unequivocally that it is not. What I believe 1054 does and seeks to do is it addresses this tiny little swath of non-respondent parents that mirrors the non-respondent parents in Family Court Act 1017. When a child is removed from their home, a parent who's not been caring for them steps into the picture. Maybe they're good friends, maybe they've never met each other, we don't know. The court can keep an eye on that situation, and that's a temporary order. So you get to disposition, which may just be a few months later. Guess what? The Family Court Act says we're still going to give you that option. Not only that, when you're at disposition, these are the final orders that are going to hopefully lead to the child having permanency. And that may mean that the respondent parent, who the child was removed from very recently, regains custody of that child. And so it makes sense that the court would have the option to sort of keep the non-custodial, non-respondent parent on the hook to make sure that they cooperate with that process. And if the two of them have a disagreement, it's an Article 6 question that the court will handle. I don't believe that there is any order that could be made against a non-respondent mother who has just raised her children and kept raising her children and not gotten in any trouble and
cooperated?
And had the misfortune, the bad luck to be subjected to domestic violence, which, as an aside, she had no obligation to this, but she handled it beautifully and protectively in this case, and that is in the record. When this happened, two things happened in her household. The respondent father was keeping things in the household, an apartment he owns too. He has every right to go in there. He was keeping things related to his business that were dangerous, and he was getting rough with her. And it happened in front of the children, and she went to court. And she filed her own case to get him kicked out because she knew that she could not keep the home safe otherwise, because it's his house. She needed an order, and she also knew because of the business that he was in, he was not going to violate a court order, and he never has. The different orders that have been ongoing in this case, the whole time it's been going on, he has never violated a single order.
Counsel, I'm sorry to interrupt you. I need to know how this has impacted Sari. With the deputies going to the school to talk to her, can you talk to us about Liam and Sari?
Yes. So what's different about this case from the 1017 cases is these children were old enough to cry out and to talk and to describe what they were experiencing.
And weren't they thriving with mom at that point in Florida when the
Yeah.
deputies came to the school?
They've always done well in her care. Even when they were in New York in a sort of temporary situation because their grandma was sick, the schools raved about them. The house was always appropriate. They were lovely, well-dressed, sweet children. There were never any issues. In Florida, they were at a new school. They were at a private Catholic school, small, starting out. And the three of them, this little family, the appellant and these two children, were really kind of starting afresh in Florida and trying to put all this stuff behind them. And the ACS supervision in this case really derailed that, and it really affected these kids. And she was 10 years old, almost 11 when this happened. She was at school with her new schoolmates, and these uniformed people with guns come like running into the school, calling out her name and saying they're there on behalf of ACS. They take her out of class. They interview her in a quasi-public space. Kids she wanted to be friends with saw. She was so humiliated and mortified. Her mother had to come to school to take her off campus. She couldn't even calm down. She was so upset. And after that, it was hard for her to even come back to school. But when she did come back to school after that, she started having problems that she had never had before. She started having behavioral problems. She started getting in fights. And she was very sensitive to the stigma of what this all bore, because she is a Latino child who was living in the Bronx. ACS was not unfamiliar. She knows what is associated with that. She knows the shame that's associated with that. She referred to it as being seen as one of those trauma children, that her classmates would see her that way. And so that also was an aspect of how much she suffered as a result of this. She's finally doing better now, but it took a while. It took a really long time.
Thank you.
There are no other questions.
I want to welcome the students from Project Discovery. We're happy to have you here. Our colleague, Judge Gesmer, has been working with this Bronx school for some time, and we're happy to have you here. You may proceed.
May it please the court, John Chapong on behalf of the respondent ACS. I submit, Your Honors, that appellant is trying to turn this case into something it's not.
Counsel, I have a question.
He's trying to turn this case into something it's not?
What I mean by that
is... This case is exactly what it is, that ACS is abusing the use of this section in a way that is harming families and children.
Well, I don't think that ACS is abusing anything, because I think that we have to remember that family court here is the one that authorizes supervision.
Counsel, I have a question. In connection with the order of disposition, your client asked for the children to be released to the non-respondent mother. However, the record is clear. The children were never removed from her. Is it a standard practice for ACS to ask for release orders, even in circumstances where children weren't removed, and why?
In terms of the supervision at
The
post.
children were never removed from mom. So why ask for an order of release to mom of the children?
There is no standard practice here. ACS considers individual circumstances for each case in terms of whether supervision is necessary or not post-disposition.
What was the circumstances in this case that caused you to request release for children who were never taken?
Well, I think that, Your Honor, I think that when the Family Court Act uses the term release, it's a term of art. It doesn't actually mean release from a home.
Well, I'm not talking about we're not talking about the Family Court Act.
No.
We're talking about your request of the court for this order of release.
Well, that's what a dispositional order does. I think that there's a specific enumerated.
You realize that there are members of this bench that have sat in family court. So you're not talking to people who are not familiar with the practice of family court. I warn you to understand that when you speak to us, okay?
Of course, Your Honor.
Proceed.
The point that I'm making is under, I believe it is Section 1052, there are specific dispositions that the family court can enter at the end of an Article 10 proceeding. That includes release to the non-respondent parent. So that's just the way that the term release is used, I think, in these circumstances. It's not a question of removal from the home or anything like that. It is just how the case ends, how the case is disposed of in relation to...
Counsel, I'm reading the transcripts from March 3rd, 2025, and the court says you're seeking an extension over Ms. Caraballo, and your client goes into all the reasons why, all involving the father. And at the very end, your client says, we are willing to work with Ms. Caraballo to determine the least, let me repeat that, the least invasive way in order to continue to monitor the children's welfare. Do you believe that the facts of this case lend to the least invasive way?
I think that ACS was put in a tough position here, and Family Court was put in a tough position here, because I think that if appellant is successful in getting 1050...
I think the mother was put in a tough situation here.
I understand Your Honor's position on that, but I think that if 1054 is gutted in the way that appellant is advocating for. I think that that means the irony is that there will be more neglect petitions. There will be more aggressive intervention whenever ACS has a concern.
There was
about
never a neglect against the mother. She did everything you asked for, produced the children in video, let you see her home. Yet the father didn't necessarily complete everything. She's the one that has to go through all of this. And you're saying that this opens the floodgates if we address this?
I understand Your Honor's point. I think what's
I'm
important
glad you understand it. So I need to understand, how is it that ACS is going to take greater care of how they utilize this provision so that the outrageous results that happened in this case don't ever happen again?
Well, I think, Your Honor,
Ever.
I understand Your Honor's point, but I think that, ACS has heard this court's guidance. It's heard this court's guidance.
Apparently not.
Well, after Matter of RA and after Sapphire came down, ACS obviously reevaluated, took a close look at the supervision in this case, and determined that because of
that the victim of domestic violence should have her home invaded, that her and her children should have officers show up at their school and at their house.
She went to court. She got a family offense petition. She told ACS what was in the home. She did everything. She moves with the children to Florida. And she's the one that's the bad person here?
I think, Your Honor, it's important to remember that ACS fundamentally actually agrees that supervision is no longer necessary in this case.
Yeah, but the problem, counsel, is that ACS agreed only after there was the petition filed to find this practice unconstitutional.
And filed their order to show cause on the last day of the order expiring.
So ACS can continue to try to play their game. I'm going to do these orders improperly, and then I'm going to pull them back before you can move and say, this is moved. You shouldn't decide this, court. How many families should be improperly affected before the court does something?
Your Honor, I dispute that ACS has undertaken any gamesmanship here, but I will reiterate that.
Really?
I will reiterate.
In this case, you're going to argue that? Counsel, this is not the case. Okay? I would have, frankly, I was an attorney too, and when I had to fall on the sword, I did. Right? Because it gave me greater credibility with the court. You're right, Judge. This wasn't done right, but XYZ might have been a better way to handle this. But to tell us that what ACS is doing is perfectly fine and nothing is wrong, you leave us in a predicament I don't think you want to leave us with. So I'm going to give you another minute in case there's something else you'd like to say other than ACS did nothing wrong.
Your Honor, I think that, I'm not going to disagree with Your Honor in terms of whether this supervision was reasonable under the circumstances or not, because clearly, I think that the positions have been made. I think that's what's important, though, if the court is, and sounds like the court will, determine an unconstitutional, order here, it's important to make sure that we're applying the correct standard. And I think that that is what is fundamentally the most important thing about this instance, where there is agreement that supervision is not necessary. I think that we need to remember that probable cause is not the correct standard, that particularity is not the correct standard. Now, I'll emphasize that family court was never given the opportunity to issue a particularized order, and ACS has no issues with, a determination that family court should have done so in terms of determining specifically what aspects of supervision or what aspects of contact with ACS.
ACS took advantage of the word supervision that the judge issued. The judge's order should have been more detailed. ACS only asked for video and interviews with the children, and it was much more than that. The woman is having a holiday, and the deputies show up.
I think that Your Honors, that clearly there's no need for supervision any longer in this case, but I think that fundamental principles of the Fourth Amendment should be considered in rendering the determination that Your Honors are going to make in this case in terms of what the right standard is, and we submit it is special needs analysis or reasonableness analysis, considering the important function that ACS does have, the obligation to protect children under these circumstances, even if in this circumstance, Your Honors feel that, ACS overstepped.
Thank you.
Thank you, Your Honors.
And no, the courts, what you have been sensing is not personal to you. Please know that, okay? You have a job to do. I'm sorry that you got to sign this case, okay? It ain't personal. This is not personal, but this implicates really, really serious issues for the children of New York State.
And I'll emphasize that ACS recognizes that.
Please do. Thank you.
Your Honor, just a few important quick points.
You have 1 minute.
I'll go quickly
So
then.
make them fast.
The idea that ACS has taken heed of the Second Department's decision in AR is belied by the record in this case. After Sapphire W came out, which admittedly just applied to Section 1017 pre-disposition, at disposition, because Sapphire W didn't apply to that section, ACS asked for unbounded supervision. The attorney for the child represents most of the children in Article 10 proceedings across New York. Their brief says ACS does ask for the exact same orders in every single case. Look at the amicus briefs from lawyers for children who represent other children, the public defender offices that represent non-respondent and respondent parents. ACS is asking for these orders on a daily basis. The important point of this case is not that ACS surveillance is never needed. It's that it must meet constitutional constraints, and a court must take an important look to make sure that it does. And what the lawyer for children and the advocates for children say is that it's about protecting children. The probable cause and particularity standard is not put against child safety, it's to protect child safety, because unnecessary ACS surveillance imposes enormous harm. It's what we see from the attorney for the child and what we see from advocates in New York and across the country. And I have 30 seconds, Judge? Thank you. On the probable cause and particularity and special needs doctrine that ACS is trying to resurrect. Courts, both state and federal, have looked at this issue. And from the Pennsylvania State Court to the Fifth Circuit to the Second Circuit, from district courts, we cite all of them in lengthy footnotes, is that the special needs doctrine has no applicability to here. And just like in Section 1034, where probable cause and particularity apply, so should it here. And that is going to protect children, protect survivors of domestic violence, and enhance New York City families' lives. Thank you.
Thank you. Denmark versus New Chapter. You may proceed.
Good afternoon. May it please the court. Vincent Chirico for the plaintiff appellant. This case involves a divorce proceeding, but no children. Summary judgment should have been granted in Mr. Denmark's favor based alone on what New Chapter Capital conceded in the court below. They conceded three things. They conceded that they filed a UCC-1, therefore guaranteeing their payment on this non-recourse loan. They conceded that it was a once UCC-1 on real property that the agreement doesn't allow. The agreement does allow that they can file a UCC against, and I quote from page 41 of the record, any and all personal property owned or after acquired included in proceeds received, okay? They didn't even sell the house yet in this divorce proceeding. They signed the agreement, they immediately filed the UCC-1. When in the course of the settlement negotiations in the divorce proceeding, they decided that, okay, let's talk about selling the house and who's getting what share. They could not sell the house. There was no proceeds, and yet they were kept from negotiating that. It took about a 2-year delay in trying to negotiate a release of this money so that these people could probably have come to a stipulation of settlements 2 years earlier. So, but that's something that's conceded. And it's in direct violation of paragraph 8C of the financing agreement, which says that New Chapter Capital, quote, will play no role in the prosecution or settlement of the claim, and NCC, New Chapter Capital, will not be involved in any decisions that Mr. Denemark and his attorney make in connection with the claim. So that's the first thing they concede, and that's the first basis for summary judgment. The second concession that they make is that they concede that they refuse to release the UCC-1 unless Mr. Denemark entered into a separate escrow agreement guaranteeing that they hold 50% of the proceeds of the house. They hadn't yet determined whether Mr. Denemark was going to get 50% of the house in the divorce proceeding. He could have gotten 10%, he could have gotten 80%, but they forced him to sign, they constrained him under duress to sign another escrow agreement, and they concede this point as well. And they also concede that because of this, Mr. Denemark couldn't pay legal fees that are still owed today. There's still $30,000 somewhat in fees that are owed to the divorce attorney, in this case, who worked without getting paid until the stipulation of settlement was filed. That money is still in escrow and is not being released. That's the very purpose of the agreement to come up with. So what did they do? They guaranteed this non-recourse loan, making it a loan. Making it a guaranteed loan at an 18% interest rate that is now ballooning to over $400,000, where there's $150,000 left in escrow. And we're sort of stuck with that. So based on those three concessions alone, I think that summary judgment should have been granted. There's no tribal issues of fact. There's no discovery to be had below. Either this was a non-recourse agreement or it was a loan. That's a pure issue of fact that under the Austin Instrument case that we cite in our brief from the Court of Appeals.
Counsel, how does the sweetheart guarantee that's accompanying this document play into your analysis about whether this is a loan or something that's more of a contingent agreement?
I think it's irrelevant given the fact that the money's still being held.
Okay.
It's not.
But it, let's take another stab at that question.
Okay.
Right? Because if the sweetheart provision says, if you get back with your wife, you got to pay me everything I put up, then what is that?
Well, that's a contingency that's not relevant here because they did not reconcile. They, in fact, entered into a stipulation dividing property, and they did divide that property, and they did finalize their divorce, and the money's still being held.
Well, I mean, their argument is that this is not a loan because it's contingent on how much is obtained from the settlement. But if that contingency is eradicated if the parties get back together and there's a guarantee that you have to pay back the full amount of the money, then is it contingent or is it a loan based on a condition that's accompanying this agreement?
That condition is limited to a reconciliation where there's no legal fees owed, where there's no court action anymore.
Oh, does it say that in the contingency, in the sweetheart guarantee, that you're only on the hook for the sweetheart guarantee if you have not expended any legal fees at all?
No.
Okay. So there's a potential that you could be going through the divorce proceedings, have expended some legal fees, and you've received the money, right? And you've used some of it, but now you're not going to get a settlement anymore because now you're back together.
I would agree that under those circumstances, if there is a reconciliation, he would owe the money based on that contingency.
Okay.
There's no other questions?
Nope. We'll wait for rebuttal.
Afternoon, Your Honors. Daniel Lopresti, McCalla, Raymer, Liebert, Pierce, for the respondent cross-appellant.
How is filing a UCC, I forget the number of the document that was filed, right?
UCC1.
The UCC1 document that now serves as a lien on the property.
Right, well,
how does that not impact the negotiations in a divorce?
it actually didn't in this case, but...
It didn't?
It did not, no.
He said that he had to sign, you guys, because of the lien, he couldn't sell the house. He had to agree to your terms in order to move the property.
Let me tell you.
So how is that not impacted?
Can I tell you what the terms were, Your Honor? Because that's very important. The terms were, we'll release, you hold your share of the money in escrow so we still have security, and when the divorce is over, you pay me what you owe me, which is exactly what the original agreement said.
Was he advised of that when he entered into the agreement in the first instance? That upon signing the agreement, I'm gonna file a UCC-1 on your house so that you can't, you was told that?
No, paragraph 3 allows my client to file a...
I didn't ask whether the agreement allowed you to do it. My question was whether he was told that you would do that. I mean, you did it the next day. So was he told that as soon as you sign this, we're gonna file that UCC on you?
Was he told that other than in the agreement he signed, and by the way, he didn't...
Well, other than him having a document that says that there is a potential that that could happen, was he actively told that that would happen since you did it the very next day after the agreement was signed?
I think that's unclear from the record.
Okay.
But I think it should be understood when you grant someone a lien against property, a lien against personal property in this case, that you can expect it to be filed and to be filed immediately. Because if we waited, as appellant suggests, if we waited until after the divorce was over, we would have had no security. Because in fact, they sold the house in 2021 and settled the divorce proceeding in 2022. So the house would have been sold, the money distributed, and my client loses the security.
You entered into this agreement in 2018. I mean, there were years there before the case resolved and whatever. I mean, it seems that you filed this and it made it very difficult for Mr. Denemark to be able to sell the house. He said it took 2 years, and he had to negotiate with you under duress to sign the escrow agreement. I mean, it didn't sound like this was done very cooperatively.
When they came to us and said, we want to sell the house, we said, fine, just don't give away the money. That's all we wanted. Don't give away the money because we may be entitled to that when the divorce is settled.
You're trying to secure your interest, right? You're attempting to secure your interest in the home, right?
Not in the home, in the proceeds.
In the proceeds, right.
In the proceeds
But you're trying to do that through the house.
And I should just point out that...
Let's go back on this whole idea of securing your interest, right? You're trying to secure what you've paid or what money you've given to Mr. Denemark. And so it's no longer contingent, right? You're trying to make it a secured interest.
So that's the trick here, Your Honor. The
trick.
Contingency isn't...
Say that again.
Contingency isn't he won't pay us back. The contingency is he may recover nothing under the divorce and then we get nothing. For example, the sale of the house resulted in proceeds to him of $262,000 and change, which would not have covered what was owed to my client. If that was all he recovered in the divorce, my client would have lost about $100,000 or so, or maybe more than that. So that's the risk. The risk my client always took was not whether the appellant would pay what he owed. The risk was whether he would collect on his claim. If he didn't get the funds in on his claim, if he got zero in the divorce, my client would get nothing.
In terms of agreeing, in terms of coming up with a number of how much money to loan someone, how is that determined? How do you come up with that?
I believe my client does an analysis of what they expect the recovery under the divorce to be.
Vetted through your company, though, right?
I'm sorry?
Your company vets that analysis, right? You're not just going to agree to loan someone $200,000 without having a sense that there's a potential recovery of $200,000.
Correct. And my client takes the risk that they're wrong in their assessment. But there's still always that.
But you also make sure you secure that interest by filing a UCC
That's
claim
not the
on
interest that's
personal
secured.
interest.
What's secured, what should be secured and is not secured, so the client still hasn't gotten paid despite the lien being filed. What is secure, what they're trying to secure is their right to payment once there's a recovery.
So just so that I've wrapped my brain around what we're dealing with here, we're dealing with purchasing the recovery or settlement of a divorce proceeding from an individual.
Right, particularly Mr. Denemark's share in the divorce proceeding. So if he recovers money in that divorce.
As a matter of public policy, where matrimonial lawyers aren't able to get contingency fees for their clients, do you think that it's appropriate that it be allowed that a company can purchase a matrimonial settlement? Right, because that impacts so many different things when you're talking about a relationship between two people that are ending, and there may be custody issues, there may be an issue where you can agree to certain things, but now you know you owe all of this money to a company who's upfront some of the money for your legal fees. So the things that you can give and take on, the ways that you can do settlements, you may not necessarily do because you're trying to get more money from the marital assets.
Well, I mean, that issue wasn't raised in this appeal, but
it's a concerning issue.
I understand.
At least for me.
I understand that. The bottom line is
because it's not like you're selling a regular settlement. It's not like it's a tort settlement, right? Where there's a claim that might be recovered, or it's very different. A matrimonial agreement, a matrimonial settlement than a regular personal injury settlement.
But the setup is pretty much the same.
No, it's not. Because in a divorce situation, the parties and certainly the attorneys, the court are always looking to see is there a way for reconciliation here so that the case doesn't have to proceed to a full-blown divorce. Right? And this entire setup puts other factors, financial factors, in the mix that may prevent a reconciliation. I mean, do we want as a society to have funding of divorce actions such that that happens and then I borrowed so much money, now I gotta divorce you because I can't pay it back otherwise?
Well, that's why we have the sweetheart agreement, Your Honor, and that actually provides for a lower rate. It actually it's a 12% rate if the parties reconcile to actually encourage reconciliation, and also if they reconcile, it lowers the amount of the.
If you want to encourage 12%,
so if he doesn't, if he doesn't recover, you walk away from each other.
Except for if
right? But if they get back together, he owes you.
Correct. Correct. And that really sounds to me like it's a legislative issue whether such agreements would be allowed rather than something for the court to decide without.
I don't know about that. Courts opine on public policy matters all the time. So.
Okay.
I don't know.
I mean, and the only other issue on that is when you have someone who wants to get a divorce and can't pay the attorney.
I think this guy he was good, don't you? He had two businesses.
But yet he chose to take money from my client.
True. Yep.
And not pay it back, by the way, which is why we're seeking summary judgment.
Got it. All right. You have a minute.
Very quickly, I think the court makes a very valid point. In a personal injury context, there's nothing to lien. So embedded in that negotiation is an interest rate that says, if you don't pay it back, we'll come after you. We'll sue you. Here, counsel indicated, and New Chapter says, if they sold the house, there would be no security. Isn't that the very purpose of this kind of agreement? If he didn't repay it, Mr. Denemark didn't repay it, to Your Honor's point, They can come after him. They can sue him just like they would in a personal injury context. There's no security. There shouldn't be a security. And I do agree that it does impact matrimonial actions. And perhaps the legislature should take a look at that in the future. But the other quick point I wanted to make is that they build their interest rate and their analysis into these risks. They're charging Mr. Denmark 18% interest, which under this law, under state banking law, is usurious. And that's why we think that Mr. Denmark's entitled to a rescission of the agreement. And again, this whole discussion about the UCC1, personal property. Thank you, Your Honors.
Kashawn Jones, People versus Kashawn Jones. You may proceed.
Good afternoon. Sarah Siegel for Appellant Keyshawn Jones. I'd like to start with the waiver in this case because it's really troubling. On the day that Keyshawn Jones, then 24 years old, allegedly waived his right to appeal to this court, he was not on the medication. He was not on any medications, according to the colloquy, even though he had been medicated for at least a dozen different psychiatric disorders beginning at the age of 4. Not only was he not on his medications, according to the colloquy with the court didn't inquire. Not only was he not on his medications, the most recent of the 3 separate 730 exams in this case specifically warned that if he were not taking his medications, there was a real risk that he would decompensate again. There's a complicated history in this case, but it's fair to say that Keyshawn's competency, his ability to rationally relate to anyone in a room, really rose and fell with his willingness to take his medications and sometimes his turning to self-medication through illicit substances, which I do not endorse, but is important for the court to understand, and I believe that the court does understand that in many circumstances, people who suffer from severe debilitating mental illness, and there's no doubt that Keyshawn did suffer from severe mental illness. He was assigned an ACT team. Your honors know how rare that is. He was one of just 56 children at any given time who was treated in the long-term treatment facility of August Acorn, exceptionally rare. The average stay there is 30 months, or was at the time that he stayed. He was designated seriously mentally ill by Rikers. Over the course of this 3 730 exams, which were separate from a series of civil commitments or a series of hospitalizations related to a civil commitment that occurred outside the bounds of this criminal action. He is really, really sick. And so the fact that he was not on his medication on the day of this waiver is important. So too, it's important that on the day of this alleged waiver, he made really bizarre statements that betray his lack of understanding. Despite any conversation that he may have had with counsel, counsel is doing something that defense attorneys sometimes have to do after conversations where their clients don't understand, which is get the court to say the thing that the client is unable to hear or unable to accept from counsel. So counsel is saying, Your Honor, my client wants me to ask you, could you release him before this plea where he's remanded and been remanded for more than a year, and he has 2 separate indictments, and he's a predicate? Could you release him to go home before he takes the plea? Obviously, the court's not going to do that, but the counsel has to make that request. Later on at sentencing, there's another...
That's, in your argument, that's evidence that he was under some sort of mental illness impact at the time?
It's certainly evidence that on this record, I apologize, the question of waiver, the sufficiency of a waiver is a question of record sufficiency, whether the record is sufficient to show that it was a knowing, voluntary...
No, I understand that. I just wanted to know what was the legal import of that factual scenario that you just mentioned.
You're saying that defendants who don't have mental disease don't ask their lawyers, can I go home today, even they come on.
That's not what I'm saying, Your Honor.
Exactly. So that is not the test for the court, right? The fact that he he asked his lawyer, ask him if I could go home today. That is not the test for the court.
Absolutely, absolutely. It's just
So is there anything else in this record that would evince delusional behavior, you know, him looking and talking into space or something in the courtroom, anything that would have alerted the court that he was beginning to decompensate again, because it was only, I think, like 2 weeks from his last 7:30 exam where he was found fit to the time that he took the plea, right?
That is correct, Your Honor.
So in the colloquy where he says, I didn't take my medication, right? The exact question was, have you taken any medication that would prevent you from being able to understand what's happening here today, no?
No, Your Honor. You do see that frequently in other records. That was not the question here. The question was, have you taken any medication today? The answer was no.
Okay.
And so if we had seen a question like the one that Your Honor just phrased.
Do we know when his medication regimen is given? Because he was incarcerated at the time, right?
He was.
And we know, certainly I know, that prisoners who are incarcerated, when they're brought to the courthouse for a court date, they are awoken at about 4 o'clock in the morning to put them on the bus to get them to the courthouse, so that if his medication regimen was in the middle of the day or he would not have taken his medication because he got on the bus beforehand. But one day's not taking the medication does not cause automatic decompensation to the degree that we have to question whether he was in this process knowing intelligently.
What we know about, we don't know what time. The record doesn't show that. What it shows is that he was not on medication. What it shows is that the doctors who repeatedly examined him found that he just stopped taking his medication pretty often, actually, despite being on the mental observation unit. I mean, he was smearing feces on the windows of his mental observation unit cell at Rikers. He just stopped taking his meds, and Rikers was not really able to supervise him with respect to that. We also know that he was wearing mitts for safety reasons that could not be removed during the course of the plea. We know that he did not read the appeal waiver. That's what counsel said, that he has not read all of these documents. This record, and I do want to just mention one other thing, and it's that it's beyond the can I go home today. It's that at sentencing, he still doesn't understand what's happened. He asks for time served. He's a predicate. That's impossible. So he doesn't understand what's going on. And it's not, as you know, it's not my burden to prove that he didn't know. It's the burden of...
I understand, and again, the fact that a defendant says that, to me, does not automatically mean that there's a lack of understanding, because defendants who are about to go to jail will say and do anything to try to avoid that from happening. But we'll hear you on rebuttal because I've doubled your time.
Thank you.
You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. Andrew Kim for the people. The defendant's claim, the excessive sentence claim, is waived in this case by the valid waiver of appeal. Based on the record, the defendant clearly informed the court and confirmed the court that he understood the conditions of the waiver, that he had discussed it with his attorney, and that any questions he had about the waiver appeal were answered by his attorney as well. And I will just note that this is an attorney who on the record stated that she was very familiar with the defendant, that she informed the court that she had spent a lot of time with the defendant throughout the course of the pendency of the case. And so there was no reason for the court to question the defendant's confirmation and the counsel's assurance that he understood the valid waiver or the conditions of the waiver of the appeal here. If I may just turn to the excessive sentence claim, if Your Honors were to consider the merits of the claim, the sentence here was very reasonable. It was very fair. It was certainly not unduly harsh or severe. The defendant had three separate and distinct incidents that were covered by 2 indictments. The prosecutor on record said after much discussion, the parties did come to a resolution here, and the ultimate plea was a departure from the top counts. The defendant ultimately pled guilty to the attempted burglary in the second-degree charge, not as a sexual motivated felony. And because of his violent predicate status, the statutory minimum was 5 years prison and 5 years post-release supervision. And so the fact that the defendant ultimately was sentenced to 6 years prison and 5 years post-release supervision as a concurrent sentence to cover all of these cases was very reasonable, and it was certainly fair for the judge. And if there are no further questions, the people will rest on their brief.
Thank you. You left over a couple of seconds. I'm going to give them to you. Go ahead.
Thank you. I want to turn to some bread and butter issues with the appeal waiver. First, that it's really identical to the issue that invalidated the waiver in Lopez, where the court says, had you chosen to go to trial, then you would have the right to appeal. That's what the language is in this case. It's what the language was in Lopez. It's what the problem was in Lopez. And so it's invalid on that basis. But I would encourage the court to take this opportunity to clarify that mental illness really does have an impact on the kind of colloquy that we should be having. Obviously, this colloquy was insufficient without a mental illness, but where there is one, and it's really florid. I mean, there's also a suggestion from his doctors that he has cognitive limitations. We know that he didn't read the waiver. Courts, I would ask the court to encourage trial courts to take more care, to make the colloquy more clear in cases like this one. And I would also say just with
I don't disagree with you, and I would come back at you and say your organization should make sure they communicate that to the state legislature, because if you want to have this as a part of how we do business, that's the best way.
Thanks for putting it on video, Your Honor. I appreciate that.
Okay.
With respect just to my colleagues' points about counsel, that actually further invalidates the waiver here. Counsel had known my client since he was 14, at least had been representing him since he was the age of 14. And the particular colloquy in this case around the waiver gets a little bit strange in the way that it functions, because my client is wearing mitts for safety reasons that cannot be removed, he doesn't actually handle the document. And so counsel signs it on his behalf. And in the colloquy, there's no mention that my client has a right to counsel on appeal. That would be its own issue, and it certainly is. But instead of being told he has the right to counsel on appeal, the only attorney he's ever known since the age of 14 is the one signing the right to the waiver. That really undermines any understanding he might have had that he would have a further right to counsel on appeal, because the only attorney he trusts or has trusted, even though some of the 730s have been because he was suddenly making accusations, paranoid accusations against counsel, she's the one who's saying there's no appeal here. So why would he think that he had a right to one or a right to counsel further? I would just, with respect to the excessive sentence point alone, the difference here that we're asking for is between 6 and 5. It's 1 year. And I just don't understand how incarcerating a severely mentally ill young man for an additional year when he is not receiving appropriate services from docs, he is not receiving appropriate mental health services from docs. I don't understand how that makes us safer. It certainly does not make Kashan healthier, and it doesn't answer the question whether the people have other remedies for this, and they do, civil remedies. Thank you.
So much. Hamovici versus Castle Village owners. And I'm sorry if I mangled the name.
Good afternoon. May it please Your Honors, Gregory Cioris for Plaintiff Appellant Gabriel Hamovici, who's appealing two discovery orders. First error deals with privilege, attorney-client privilege. It's going to be discussed more than once. About 15, 16 documents have come in with redactions, one being entirely omitted, and the basis was attorney-client privilege. However, no privilege log was provided. And as this court has said on, I can cite the cases during the brief, it's legally insufficient to be raising claims of privilege when you don't produce either a privilege log or seek a judicial review in camera of what you're claiming is privileged. So that should be disclosed. Second issue now goes to the former lawyer of the cooperative who, on March 7th, in response to my client's shareholder demand, wrote a letter deeming my client engaged in objectionable conduct. It doesn't say what it is. And worse than that, neither the bylaws or the proprietary lease use the word deem. There is no authority in either document where a lawyer or anyone, a board member, can deem anything, let alone objectionable conduct. Why? Because certainly objectionable conduct can lead to the termination of a lease, which ended up happening here. We want to question this lawyer, not for any legal opinion, for facts. Who told you to write the letter? How did it come about?
Didn't you have a deposition of at least one other member of the board? Why wouldn't that have answered the questions? Why do you need another board member?
Because he equivocated, he never gave a firm answer. He never said, and I showed him the minutes of both February and March 2022. It says nothing about a lawyer writing a letter or deeming objectionable conduct. How did this come about? His answer was, and it's in the brief, we had discussions.
But didn't the minutes surmise that there was a discussion about this tenant and that the board had determined that he was engaged in objectionable conduct?
No, not those minutes. If you look at the minutes, we have them in the record.
Right.
You'll see, he's not named. If you don't have the plaintiff named in them saying that so-and-so, we find objectionable conduct or we're raising the issue. If you're gonna raise objectionable conduct, the lease says there's a right to cure. And as this court has said, when you have a right to cure, and especially a time period, here it's 30 days, it has to be upheld. That was an opinion by Judge Acosta back in 2021. It's in the brief East something construction. So we want to depose him, again, not for any legal opinion, but how this came about. How are you writing this letter? And I think it's a fair issue that should not have been precluded. Judge based it on Liberty Petroleum against
So if the answer is my clients asked me to, how is that not privileged communication?
The follow-up question would be, did you read the lease?
See, but this is the slippery slope.
Yeah, we're going
Okay?
circular.
This is precisely why the court did what it did, right?
Well, on a fact question,
Because you want to question, as an attorney, if your client says, I want you to file this, send that one a letter and threaten him with a lawsuit, blah, blah, blah. You cross-examine your client and say, show me the proof that I can write that letter.
if there's a lease, Judge, is
Okay?
here.
Look, my point is that there is no way, I don't see how you can question this attorney and not engage in discussion about his representation of those clients.
I'll put it another way. Let's say the client didn't tell him to write that, or the client never told him to use the word deem objectionable conduct. I think that's a fair answer.
Again, how the lawyer decides to write the letter is not a subject that you are entitled to depose on. That is legal theory, legal analysis, and you don't have a right to question him on that. No. It's like him deposing you. Why do you think your client hasn't engaged in an objectionable conduct? It's inappropriate. You're his attorney.
Yeah, but you can't deem it, Judge. The word deem, I think, is what is the fork in the road.
That's what you're hanging your hat on, the word deem?
Well, it's not in the lease.
Okay. I will hear you after I hear counsel. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the court, Alex Rabinowitz on behalf of respondents. As Your Honors know, the Supreme Court has broad discretion to supervise discovery, and its orders to that effect should not be disturbed absent an abuse of discretion. There were no abuses of discretion here. I'm going to start with Mr. Cohen's deposition, because that took up the bulk of appellant's argument.
Is it appropriate for a court to find that a witness shouldn't be produced because of privilege issues where no privilege log has been provided?
Your Honor, under these circumstances, no privilege log was necessary.
Why?
Because a privilege log is necessary when documents are withheld. Documents were not withheld here. They were very, very limitedly redacted. A privilege log will tell the requester of the documents the date, the type of document, the subject matter. Here, they were emails. They were produced. It says the sender, it says the recipient, it says the date. It says everything up until the word Jeremy, the name of the attorney, and then it redacts the advice relayed. So on that point, Your Honor, no privilege log was necessary. On the Cohen deposition, Your Honor, there are two main points here. First, appellant concedes by failing to address that the trial court soundly declined to order the deposition of Jeremy Cohen because appellant improperly sought the relief on a cross motion against a non-moving party, not just a non-moving party, a non-party who, the record reflects, was never served, and the appellant has never refuted that Mr. Cohen was never served. Mr. Cohen wasn't there to be heard. Secondly, all of the arguments on substance are without merit because they're hanging their hat on the word deem in this letter, right? The letter says Castle Village deems Mr. Haimovic's conduct as objectionable. It's the board's determination. They already had the opportunity to depose the board. And appellant's counsel said that that witness equivocated. He did not. He said, counsel asked whether the board authorized Mr. Cohen to draft that letter, and the witness said, I'm sure. He did. That's not equivocation. He received confirmation. It was the board telling the attorney to write the letter. So there's no basis, look.
Do the minutes of the board meetings that have been disclosed point to the date when the board made this determination?
There's a separate resolution. First of all, this March 7th, 2022 letter is not even the mechanism by which the proprietary lease was terminated. This was an initial letter saying, stop doing what you're doing. Then there was a whole bunch of procedure. It's outlaid in our papers. There was a notice of termination. But before that, there was a multi-page notice to the appellant saying, these are all of the things that you've done that we think are objectionable.
Counsel, who signed the notice of termination?
Notice of termination, I believe the president of the board.
Wouldn't that be authority?
Authority for what, Your Honor?
Commence an action in order to get the objectionable conduct allegations moving.
To get it moving? To get it?
I thought, what is the notice of termination?
The notice of termination was issued after a hearing and
regarding objectionable conduct.
Regarding objectionable.
That's what I'm talking about. I thought you didn't understand what I'm saying. The notice of termination reflected the decision of the board that there was objectionable conduct.
I'm sorry, Your Honor. Yes, absolutely. And there was a resolution outlaying it too.
Right. So why would you need the attorney?
And those were produced, those resolutions, yes?
They were absolutely produced, and the board's witness was questioned about them all day. Right. If Your Honors have no other questions, I'll rest.
Thank you.
Let me rebut these points. First of all, the letter of March 7th, and it's in the record, of course, doesn't say stop doing things. It had deemed him, it deemed objectionable conduct. And again, that cannot be done.
It deemed him what? I'm sorry?
Objectionable conduct. It doesn't say the objectionable conduct. It doesn't make any listing of what the conduct is.
In that March 7th letter.
That's correct. It just says, we deem objectionable conduct. What is it? Who knows? Who knows? Second, when they speak about the claims made of objectionable conduct, we raise this and we show this in the record. Never signed by anyone on the board. Never provided a notice of cure, which again defeats predicate notice is not there. And finally, going to that termination.
The March 7th letter that said you're deemed behaving objectionably and stop it. Right? That's not.
No conduct. The conduct is nowhere mentioned. In other words, to say, you've been playing the drums at 3 in the morning. You've been knocking on people's doors.
You've been screaming at pregnant ladies.
Right,
and
exactly. You've been
Screaming
saying-
profanity in front of children.
Right, all the above
Those things, right?
never was stated. So you've got a finding, you got a fait complete as of March 7th. You've already painted this man.
No, it's not a fait accompli at March 7th because he doesn't, that's not the termination notice, right? That's later.
But
Later.
it's later. The formal termination notice is later. That is a resolution. And that's one of the things we want to speak to the board president about, because there was never a finding of fact regarding any of the allegations. And if you don't have a finding of fact, if we follow Lewandowski, especially Pullman, where a judge in a court there's a heightened vigilance when you have termination. And I'm trying to help the judge, the trial judge, in that quest for the heightened vigilance to show that what they should have done was never done. Thank you, Your Honor. And that's why we want the discovery.
Thank you.
Thank you. Good evening.
You too. Home safe. People versus Franklin Quiles. You may proceed.
Good afternoon, Your Honors. May it please the Court, Desiree Sheridan for Appellant Franklin Quiles. I have another waiver issue for you. In this particular case, I wanted to address the appeal waiver, which I submit was not knowing, intelligent, and voluntary. So contrary to my adversary's argument, timing is actually, I believe, quite relevant. And in this situation, Mr. Quiles evidently signed a written waiver, but prior to receiving any information, instruction, or description of what the appeal waiver entailed. And I would also distinguish this case
Who
from...
gave him the waiver? I would presume it was his lawyer.
I don't know if the lawyer gave him the waiver, or if the court gave the waiver to the lawyer to give to him, if the court gave it to him directly. There's nothing in the record that shows how he
The judge
received.
normally doesn't hand over the waiver to the defendant themselves. They're sitting on the bench. And
I mean-
the defendant is over there. So usually it's his own lawyer.
They may have given it to the lawyer who then gave it to him, but the record does show it was signed when he already got into court. It had been signed, but there's no indication whether he knew what was in it when he signed it. Saying that he recognized it as a waiver doesn't mean that he understood what was in the waiver itself. And he was not explained the waiver until it was signed. And I would point out,
What appellate rights was
let's
survived.
let's say we agree with you that it's not the best waiver. Why should we reduce here anyway?
well, I think most significantly about this waiver also I want to point out is that not only was it like a two-sentence description, but also very significantly, the judge did not indicate that any rights survived this appeal waiver. Like she essentially.
Said the case would end here with
Correct.
the plea and sentence,
Yes,
as my
yes.
colleague said.
Yes. Okay.
Let's-
Okay, so then we'll move on to the issue then. So moving on to the issue,
Explain
which
to me why we should reduce, and even if there's a bad waiver.
And aren't you, your client right now is on post-release supervision, am I correct?
he is on parole,
Yeah,
correct?
so he is asking for just a reduction from 2 years to 1 year.
Correct. He's asking for reduction in his post-release supervision, and I would submit that under.
How long has he been on parole?
He has just gone on parole in.
Why would we do that?
Well, because he will at some point have to serve post-release supervision, and of course there's all sorts of tripwires and requirements and.
Not if you do what you're told.
But again, you know, if he's trying to move on with his life, if he's trying to work, if he's
Didn't
trying
the
to.
defendant have 6 total convictions already?
He does have prior convictions, but he has spent, 6, 7 years incarcerated, and, now he seems to have been getting his life together, and I think that additional years.
Isn't having to walk the straight and narrow a better way of making sure that he doesn't fall off the road? Right? So I understand what you're saying, but the same argument can be made on the other side, right? It's a tripwire, but it's also a guardrail to help some people who need guidance and structure to stay within the lines, right? So, the reduction of 1 year
Well,
for someone with 6 prior convictions doesn't sound like the most sound thing to do here.
I mean, the reduction of that 1 year would probably be more beneficial to his moving forward than it would be to prevent any sort of recidivism or
Counsel,
protection.
didn't probation reports that based on defendant's criminal history, he hasn't been deterred from reoffending and should serve a period of incarceration?
Well, he has served his period of incarceration, yes.
Counsel, wouldn't he have availability to the less is more statute?
I believe that they did apply that for him, so, but even with the application of that, I mean, it's 1 year of post-release supervision. If it means that maybe he can avoid, I mean, post-release supervision includes having to respond to a parole officer, or, has certain.
That's not a bad thing for someone who doesn't know how to stay within the lines.
But certainly at the point he's gonna be serving this,
All right.
it seems like.
We'll hear you on rebuttal. We've got the red light, and I've got two people who have been patiently waiting back there, who are at the end of the calendar. Go ahead, counsel.
Good afternoon. ADA Mallory Phelps for the people. Regarding the appeal waiver, defendant told the court on the record that he understood the written waiver, that he had discussed his plea and sentence, including his right to appeal with his lawyer, and that, again, he had understood it. So even though the oral colloquy was quite short and not the best one, I agree.
Yeah.
The written waiver was understood and explained to defendant before he signed it, and it was signed on the same day as his guilty plea.
Why don't you tell me why, notwithstanding this waiver, there should be no reduction?
Well, notwithstanding this waiver, as the court was talking about before, the Less is More Act applies. So if he behaves for a year, he will get only the year. So what he's asking for, as long as he has good behavior, he will receive due to the Less is More Act. Further, he was given a very lenient plea. He originally faced 15 years in prison and 3 years of post-release supervision, and he was given 2.5 years in prison and 2 years of post-release supervision. Thank you.
Thank you. You have 1 minute.
So yes, just to reiterate, it's 1 year, and I would ask the court, to give the year to Mr. Quiles' benefit and, let him have that year off since, of course, as I had mentioned before, post-release supervision does come with conditions and reporting, and just to give him the benefit of that year to reduce his post-release supervision. And if there are no further questions, I will rest on my brief.
Thank you. Have a good evening, ladies. And last but certainly not least, Izquierdo versus Amsterdam Avenue redevelopment. You may proceed.
Thank you. Good afternoon. May it please the court. Deborah Bacardi for the appellants, Amsterdam and Pavarini. I apologize.
Bring that mic closer to you since your voice is
Yeah.
because we're not going to be able to hear you.
Okay. So while the motion court properly determined that Amsterdam and Pavarini were entitled to contractual indemnification, they made a condition. The court made it conditional. We believe that it should have been unconditional. Even though the 200 and the common law negligence claims were withdrawn, the motion court did not go through the analysis at oral argument below of whether Amsterdam and Pavarini were negligent. And
Is there any showing, any evidence whatsoever of negligence by either of those parties in this case?
Nothing. Amsterdam was not present. They're the owner. They were not present at the site. Pavarini, general contractor, general supervisory. But there's nothing to point to say that it shouldn't have been unconditional contractual indemnification.
This is a means and methods case, right?
Yes, exactly.
So on this record, we know that it was the plaintiff's employer, the foreman, who gave all the instructions, et cetera, correct?
Yes, Mr. Castillo was very specific. He gave great testimony. He gave an affidavit. He gave all the directions to the plaintiff, and the plaintiff to substantiated that as well. And just very briefly on the 241-6, we believe the entire 241-6 should have been dismissed. And they're all enumerated in the briefs, but even 1.7 D, E, and F, there was no slipping hazard. The plaintiff never testified that he slipped on the ladder. He testified that the ladder shook, the ladder moved, but he never testified that he slipped. So these...
Well, the fact that he said that the ladder moved does implicate 241-6 liability because ladders are supposed to be secured and it shouldn't shift. So the fact that that's there means there's an issue of fact as to at least that part of 241-6 with regard to the ladder?
Arguably on the 1.21, arguably, although we believe that they don't apply, but clearly on the 1.7 and the 1.5C3, we just don't think that they apply. On the 1.21, it's a flaw or defect of material. There was nothing actually wrong with the ladder. The plaintiff testified he used it immediately after the accident. Mr. Castillo used it after the accident. So everyone was using ladder. The ladder didn't fall. He testified that it moved. So there was no defect of material as we propose.
Okay, all right.
Good evening, Your Honors. Anna Higgins for ECDNY, the employer, and respondent. Just to answer, there is evidence in the record as to active fault on behalf of Pavarini.
Tell me what.
The Michael O'Leary, Jorge Fernandez, that's the supervisor. He actually testified that part of his responsibility, site safety supervisor for Pavarini, who's the agent for the owner, was that part of his duties included inspecting the ladders every day. And that ladder that day he inspected. So to the extent, and Judge Schumacher discussed that during the transcript and in his decision.
Except what evidence is there that there was any defect in the ladder?
It's that it moved. And that's why the court.
The fact that it moves doesn't mean that there's a defect in the ladder. It means that the ladder wasn't secured.
Exactly. And that's part of the.
That's not a defect. That's a different thing.
You're right, Your Honor. My argument was based upon what Your Honor just said under 241-6. If there was an issue with the ladder moving, it would be a violation of, or there would be issues of fact as to whether there was a violation of 241-6. Right. On that issue, right. And that's why the judge during the oral argument, he said that we have all these different issues or different varying. How many times, the plaintiff went through like 3 or 4 different versions of how the accident happened, one of which included the ladder shifting or violently shaking. And to the extent.
Nope. The plaintiff didn't say that. That came from the question of the attorney. He used the word violently. The plaintiff never used the word violently. That was the question being asked. So I don't think that's an accurate statement. That is not what the plaintiff said.
What the record reflects is different testimony versions and why Judge Schumacher denied summary judgment on 240 and denied summary judgment on 241-6 was because, and he accurately, correctly pointed out, whatever version the jury believes, there's different versions. Now, if the version that I want to discuss before this court as to why the conditional indemnity to Pavarini was appropriate was that these 3 witnesses on behalf of Pavarini testified that they had authority to stop and control the work, they had authority to stop any safe conditions.
So, counsel, we know that general supervisory duties does not give rise to liability of a general contract. We all know that.
Correct, but in this case, it wasn't general, Your Honor.
Let me finish. In the face of the plaintiff withdrawing the 200 in common law negligence, what is left? There's no pleading that says that Pavarini was negligent.
240's left and 241-6
No,
is
but
left.
negligence is different than 240. That's a statutory claim. The statutory claims remain. But with regard to the common law negligence and 200, that is withdrawn. So how can you assert negligence of Pavarini if the plaintiff have not even done that?
Because that's a very good point, and this is what we discussed in our brief. Under 241.
I didn't understand this, so please explain it.
Yes, under 241-6, the court and the jury is going to have to determine whether there was active fault on behalf of the parties here based upon the version of one of the versions of the accident, which is the ladder moving. If the jury decides to believe that version, that the ladder moved, Jorge Fernandez testified he inspected that ladder. So the jury would have to infer whether that inspection of his ladder that day before the accident was sufficient. And that creates an issue of fact for active fault. Whether the fault is little or not, it's still there, and that's why the court denied unconditional indemnity. It was correct to grant conditional indemnity because of the issues of fact regarding which version of the accident the jury is going to believe occurred once this case goes to trial. Thank you.
You have 1 minute.
There's just no evidence that Pavarini was actively negligent. Mr.
Well, the
Castillo said.
only thing that counsel is claiming was that maybe there was something that happened during the inspection, like maybe he didn't inspect it right, but is that active negligence?
No, not at all. I mean, if the ladder moved, we know Mr. Castillo is the one who secured it, you know.
I mean, I have a picture of it. There was something tied in the middle.
Yeah.
I mean, I saw that, and I mean, it was still standing at that particular time. I don't know what's the matter. You don't have to prove what's the matter with it, but it was still standing.
It was still standing. And not only was it tied, it was nailed in, cemented in.
Right,
like
there was
nailed in.
testimony about that, right.
But there was also testimony that throughout the day, that tie would become loose.
Right.
And so had to be checked to make sure it was still secure.
And that was Mr. Castillo who was checking it.
Thank you so much. Ladies, have a good night.
Good night.